I was already mentioned before this vacation. Lordship asked me to mention here is after
No,
vacation.
this
This is a matter. A notice of appeal was late notice filed. So this should be accepted as per demand on notice of appeal. I have already filed. This to be accepted.
With regard to what?
Regard to second appeal. Notice of appeal of second appeal.
appeal, that means it is ready for hearing.
No. This is not yet ready. This only notice has not yet been served because
Section 5 application is to be disposed of.
No. This is a notice of appeal has been filed. Lordship knows, when the appeal was admitted, there is a order that notice of appeal should be served upon the opposite.
It appears to be mentioned.
Yes, my lord. And another, my lord, this same in the second appeal, application for sole appeal and died.
Application
for
this matter.
substitution.
Okay, the matter is already admitted.
Yes, admitted. Only substitution.
Yes, give the slip.
Application in consistency.
To be mentioned. Tomorrow. Anyway, it will appear as to be mentioned.
Application in connection with second appeal.
Yes.
Inclusion of an application in connection with second appeal.
Yes, application.
In connection with second appeal.
Mention one hearing matter for motor accident claim case.
Yes.
Hearing matter of motor accident claim case.
Okay, as to be mentioned first.
My lord, it's also be hearing matter, my lord. Second appeal, my lord.
A hearing matter of second appeal.
Yes, my lord.
Yes, to be mentioned.
Yes, my
My lord,
Thank you.
application for inclusion in your lordship.
Yes, keep the slip. Hearing of. Okay, to be mentioned.
I'm mentioning inclusion in the list, my lord, for hearing.
Hearing
Deeply
of.
grateful.
A motor accident claim.
Yes, to be mentioned.
Yes.
Hearing of MSCC case.
To be mentioned.
Your lordship, for hearing of MSC appeal.
Yes, give the slip.
May be permitted to mention one criminal revision determination of Honorable Justice Choitali Chattopadhyay, code number 34.
What
The
is the urgency?
17th is the framing of date is fixed for framing of issues, man. Framing of charge, sorry.
It is in the admission stage.
Admission stage, my lord.
Yes.
My lord, hearing matter, my lord, regarding MSCC, my lord.
Yes, to be mentioned.
And my lord, applications.
Yes, application.
Hearing matter, MSCC.
Yes, to be mentioned.
With your lordship's leave, may I be permitted to mention one matter of code number 34's determination, extension of interim order. Your lordship. The
Yes,
urgency is
to be mentioned.
My lord.
Extension of interim order in connection with what? No. Extension of interim order in which matter? Of this determination. Yes. No. First appeal what? Regarding claim case. Then you take instructions and then mention.
My lord, for hearing matter, MSCC, my lord.
Yes, to be mentioned.
Your lordship, this is hearing matters. 3 hearing matters for mention.
What?
Mention.
No. MSCC or second appeal?
MSCC.
Yes, to be mentioned.
Yes, lordship, 2 hearing matters and 1 application in respect of claim case, lordship.
Okay, the applications will appear and hearing as to be mentioned.
Lordship.
Your lordship,
Just
3
second.
hearing matters relating to second appeal.
Okay, to be mentioned.
To be mentioned.
Yes.
In the vacation days, my lord has passed one order.
Yes.
It's party. That the on the next day my client got the copy of the
Yes.
I filed a recalling application.
Yes.
I have already did for this.
Serve notice and mention.
Yes, Milord, I have served notice, Milord. I am handing over to your lordship's officer. May it be appear, Milord, tomorrow. I just want to try my luck, Milord, in my recalling application.
No. What is the urgency?
Urgency, Milord, by virtue of my lord's, Milord, order,
Yes.
Milord, I have been dispossessed.
What was the order passed?
Order passed, Milord, by appointing special officer. Your lordship directed, Milord, the handover position. Milord, though, Milord, before
Position
the
for what?
to
From
the
you.
tenant.
No. Question is, you are occupying the suit property and there was a
I am the
direction.
landlord. I am
So
the
you are the
landlord.
landlord, the property was in your possession.
Yes.
How? Regarding putting the padlock.
No, Milord.
Then
They were not in possession, Milord. I was in possession. The application before the trial court was pending.
the
But-
special officer has carried out the order.
Yes.
Yes.
That's
So
why,
let-
Milord.
so have you served a copy of the application for recalling?
Yes. Milord, may it appear
So
tomorrow so that.
let it appear under the heading application.
Yes, Milord. Tomorrow, Milord, if your lordship kindly.
Whatever
Milord,
it is, if the file is there, it will appear.
my lord, I'm grateful. Dear,
recalling application heading এ থাকবে। আগে তুমি মেনশন টেকেন বার যেগুলো তুমি মেনশনে দিচ্ছেন যদি 30টা থাকে আজকে 10টা কালকে 10টা এরকম করে দিয়ে যাবেন আর কি। তুমি মেনশন যেগুলো না যেগুলো মেনশন ইনক্লুশন হবে সেগুলো একটু উই মেনশন দেবেন। আজকে 10টা দিলেন কালকে 10।
Nine, I beg to appeal for the appellant, my lord. This in regard to this application, some applications were pending. And on the last occasion, my learned friend,
Oh, is the matter admitted?
matter admitted long ago,
What
2016.
is this? What is these applications for?
Two application, one application for additional evidence that was taken up earlier and that was directed to be taken up for hearing along with the hearing of the appeal.
Yes.
Another application, my lord, which is filed by at our instance, my lord, for implementation of the order of status quo, because there is an order of status quo passed by this honorable court initially at the time of admission of the appeal, subsequently when the application was taken up. It was passed in presence of learned advocate for the respondents. My lord, in the this interregnum, my lord, there was continuous disturbance of possession. That is my application, which is pending.
So you want
And
this
on the
appeal
last
to be, you want this appeal to be heard out?
On the last occasion, my learned friend was Mr. Bhattacharya was there, submitted that the appeal may be heard out, and that is the reason, my lord, this matter is appearing under the heading to be mentioned.
So let this appeal appear for hearing.
My lord.
Yes, record an order. Learned advocate for the appellant is present. The paper books are filed.
My lord.
As the appeal is ready for hearing and the paper books have been filed, let this matter appear for hearing on 21 1
I will check it up.
21 1 2020
My lord, let it be on the next week. My lord, on the next week.
27. The paper books are not.
I will check it up. So for my instruction, my
Okay,
lord,
27 1 2026 at 2 p.m.
my lord.
Paper book which a long time ago file হয়ে গেছে.
I will check it up and I will inform your officer.
Okay, then it's better do one thing. Let it appear to be mentioned once again.
My lord.
Day after tomorrow.
I will, in the meantime, I will check it up.
Okay, so let it appear to be mentioned day after tomorrow. Not today. Day after tomorrow, you just check it up.
May I please, Your Worship? Plus, I am appearing on behalf of the respondent.
This is in calling. This is with regard to what?
This is an appeal preferred by the tenants, defendants.
Doctor, I'm for the appellant lordship.
You are for the respondent.
Appellant petitioner lordship.
Appellant. You are for?
I am for the respondents.
Just a minute. It is appearing for what? Correction.
Your Lordship, there was a direction upon the appellants to file paper book by the 9th of this month.
Yes.
And to serve it.
Oh, there was a direction that it will appear on 12th December. This is the mistake.
Yeah, 12th
Regarding
of January, it will
yes,
be
it
12th
could
of
be. It ought to
January
have been
instead of
12th of January.
January, it's what erroneously mentioned as 12th of December.
So today the matter is appearing. Are the paper books ready?
Your Lordship, appellants.
Lordship, there is a difficulty, lordship. The LCR has come, but the record is lying in the court, lordship. I need to inspect the LCR to prepare the.
Yes, record an order. Learned
Unless
advocates
and
for
until-
the parties are present. This matter is put up for necessary correction of order dated 4/12/2025. This by order dated 4/12/2025, there was a direction for the matter to appear on 12th December 2025. Stop. The learned advocates was also granted liberty to file paper books on or before 9 January 2026. Stop. As the trial court's records have come, paper books may be filed on or before 29.
Kindly grant
I'm
one month.
granting you this month's time.
Your Lordship, matter is pending for 9 years and they are enjoying stay.
Okay, 30th January
30th January.
2026. Let this matter appear on 3/2/2026 for hearing
For here.
at 2 p.m. The trial court records be sent to the department to enable the learned advocates to obtain documents for filing paper books.
Obliged.
Yes, not today.
12, I appear for the petitioner, my lord. I am praying for extension of the interim order dated 27th of November 2025, my lord.
So this is the determination of Justice
Of
Chatterjee.
Justice Chatterjee Das, my lord.
Let-
I'm for the opposite party number 2 complainant.
My lord, given notice, this is a complaint case, my lord, of under section 138 of the Negotiable Instruments Act, my lord.
Interim order is going to expire when?
On January 16th, my lord. My lord, here is the order. I'm giving a copy of the order. My lord, take a chance. Let the interim order be extended and
Learned advocates for the parties, learned advocate for the petitioner and learned advocate for the opposite party number 2 are present. As the interim order granted earlier is going to expire on 16/1/2026, the interim order stands extended for a period of 3 weeks from date. The matter may be placed before the regular bench on 19/1/2026 or as and when the regular bench directs.
let it be as and when. My lord.
Only kindly make it 20th.
My lord, let it as and when the regular bench.
The matter may be placed before the regular bench as per the convenience of the said bench.
My lord, kindly be. It's a great matter. That will be better, my lord. It's very old matter, my lord. Kindly 20th January.
Regular bench on 21/1/2026 or as per convenience of the regular bench.
I'm good.
Dear Ish.
Nine kilo. Huh? দেখেছো?
Lordships, I am
What happened here is, yes,
I am telling Lordships, judgment shows only one Lordship alphabet, Devi, D-E-V-I. I have stated Lordships, the typographical
you
mistake,
see,
D-A
see,
here.
when the matter is a disposed matter, either you file an application for rectification or you move before the bench which has passed the order. These are the two options. here.
Lordship, then today my client also come, Lordship, made not this week, but Friday week this,
Question is, in a disposed matter, in order to rectify, either there should.
but not order, Lordship,
Whatever
only
it is.
first title,
No, no, what
one
is-
alphabet.
So what is the difficulty to move before the bench which has passed the order? That would be easier.
Lordship also jurisdiction, Lordship, that.
Then you file an application.
Lordship, today I am ready.
I'm making it not this week.
Friday week, Lordship, maybe, please. Because
Okay, not today and tomorrow. You make ready the application and then mail.
Lordship, today she is affirming this. I'm grateful, Lordship.
My lord, I am for petitioner.
I am for the state in this matter.
This is my affidavit service.
So is it with regard to extension of interim
Extension
order?
of
We are
interim order.
praying for extension of interim order.
Yes. When will the order expire?
3rd December of 2025. I am file time to time.
Give the order. You have the copy of that order, interim order, earlier passed.
Yes.
Annex করা আছে ওদের।
Annex
Application আছে তো, CRAN আছে একটা।
The CRAN application.
CRAN
CRAN 3.
CRAN 3
Petition. Manjit sir.
Yes, learned advocate for the petitioner and learned advocate for the opposite party, state of West Bengal are present.
Chamber.
This application for extension of interim order passed on November 3, 2025 is taken up for consideration. Our learned advocates peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this application stands disposed by extending the interim order for a period of 5 weeks or till further orders. The matter may be placed before the regular bench.
extremely already.
Your Lordship, kindly see the last order. Your Lordship was pleased to refer the matter before the Lokadans for settlement. Lokadans have been settled. Now, my lord, it is due to appear on Chat Act.
My lord will kindly pass it over. Mr. Singh is coming.
My lord, kindly fix the my lord date, it is first week of February and particular time.
You are in this matter?
Yes.
My lord will fix a date if they are.
Paper book has been my lord filed and my lord has been served upon my lord.
You are in this matter?
Mr. Singh is there in this matter. He is appearing before another court, but if my lord is fixing a date for hearing, my lord will do
Not
so.
today, okay. Tomorrow I shall.
My lord, your lordship kindly fix the date in the first week of February.
Okay, learned advocates for the parties are present. As this matter is ready for hearing, let it appear on 9/2/2026.
To my lord, instead of 4/2.
3/2/2000. Okay, 4/2/2026.
At times the 10. My lord,
No, if a time is fixed, then I have to let it be fixed on 4th.
MACC matters are usually not fixed. Only in second appeal or assigned matters, the time is fixed.
Grateful, my lord.
Sorry. My lord, 17, I am for the appellant, my lord. My lord, we have deposited the cost of the Tolobana, my lord. The LCR is supposed to come, my lord. And there was the injunction application.
This is what? The appeal is admitted.
Admitted, injunction granted till disposal of the appeal, my lord. That is available on the order dated 25th of November 20.
These two applications are disposed.
Disposed of, my lord. May I hand over the copy? Can 2 is disposed of. Can 2 is the extension application that was disposed of on the last occasion, and Can 1 is the injunction that was extended till disposal of the appeal. So Can 1
and Can 1 is for?
Can injunction, my lord. And injunction granted, extension up till disposal of the appeal, my lord. So book has to be prepared upon arrival, my lord.
Yes, record an order. Service of notice is complete.
They have appeared.
Okay, they have appeared. Learned advocate for the appellant is present. Liberty is granted to the learned advocate for the appellant to prepare paper books and file the same on or before 2/2/2000.
Upon arrival, it has to be scrutinized.
Okay, then let the trial court's records come.
Let the
as the trial court's records have not come, the matter stands adjourned till 27/1/2026. let the trial court's records be called for at the special messenger costs of the appellant.
Grateful, Lordship. Grateful. 27th of January. Grateful, Lordship.
80, my lord, I appear for the Union of India in last occasion, my lord.
Yes, actually, what the problem here is this. No, there is some defect because no Section 5 application is filed. You better file an application, sub copy.
My dear lordship, kindly pass the order that this is required to be filed by the.
Achha, record an order. The appeal is defective as application for condonation of delay is not filed. Let the defect be removed and necessary application for condonation of delay be filed, and copy of the such application be served upon the respondents. So it's better liberty to mention after removing the defect.
Let me check about what is the amount delay period of delay.
That note is not given there, but after perusal of the record, it appears.
14 days.
You serve copy also, the second thing.
19 in this matter, I am appearing for the state, my lord. There have typographical mistake in the spelling of my name, my lord. So I mention before lordship for correction, my lord. So I mention before lordship.
Yes, this matter is put up for necessary rectification. Learned advocate appearing for respondent number 1, State of West Bengal is present. Let the spelling of the name of the learned advocate for respondent number 1 be corrected.
My lord.
Other contents of order dated 31/12/2025 remain unaltered.
My lord.
আচ্ছা 456 456 20টা একটু বলে দিন না টাইমই হবে 20টা ডেকে
এটা কি চলবে অনেকক্ষণ
20টা ডেকে 20টা টাইম হবে ডেকার পর
তো রাজু
তাহলে বসে থাকা মনে হয় আইটেম 20টা হ্যাঁ হ্যাঁ পাঠাটা ওই জন্যই বলছি বললাম একটু টাইম করে নিয়ে হবে My lord, we are for the state. My lord,
will kindly see the order dated 12th of December 2025.
You are for?
I am for the OP number 2, my lord.
OP number, you are for OP number 1.
I am for the state, my lord. Yes, my lord.
I am for the petitioner, my lord.
My lord, on previous occasion, my lord, in our the order ta din age don sir.
My lord, before my learned friend, my lord, proceed with the matter, my lord. The case diary is just we have received. This is a voluminous case diary. So, my lord, I am only praying 2 weeks adjournment.
No, that is no difficulty, my lord, but there is, my lord, the direction. In previous order, my lord, dated 12th of December
Matter is
2025.
ready for hearing today.
It's a parted matter, my
Parted
lord.
matter.
So,
no, only difficulty.
what is-
You know,
what
kindly see the order. You know, kindly see the order. This order was passed on 12th December 2025 in our absence because, my lord, we did not enter appearance on that day. You know, kindly see, my lord, the penultimate paragraph and thereafter.
Yes,
As the matter is sub judice before this court, the parties may seek adjournment before the learned trial court, which may be considered.
yes.
The difficulty is this, my lord, the investigation has been proceeded with, charge sheet has been submitted. Then we have, my lord, filed the Naraji petition because all the evidence which ought to have been collected, that has not been collected. Thereafter, my lord, the Naraji petition was pending. We approached before the Honorable High Court by filing a writ petition. Honorable High Court, my lord, passed a specific direction directing the concerned, my lord, the magistrate to take up the, my lord, the Naraji petition as first and dispose it the same. The Naraji petition has been disposed of. Further investigation has been directed.
That
which
is under
on.
challenge. So
No,
that
this is not under challenge.
the order.
This is not under. This is not under challenge. The original FIR is under challenge. Subsequently, the stage is the investigation is under further investigation pursuant to the direction of the, my lord, the trial court. So, my lord, the investigation cannot be stalled.
My lord, we are on the
So
Then the
many things
application
there.
itself is infractuous.
Yes,
application,
this
my lord.
application is an
No, no, my
infractuous
lord.
application
We are on-
because they have challenged the FIR.
Yes, yes,
This
my lord.
stage is over.
I will satisfy your lordship, my
If
lord.
you come.
My-
Come
I am
the
We are
next
challenging
week.
the whole
instruction,
proceeding, my lord.
next
The
day.
initiation of the whole proceeding we have challenged, my lord.
Okay.
The FIR comes
My
in
lord,
the
next
purview.
day I will come with the all instruction. Next week, my lord, and 2 weeks, my lord. Give me
My
2
lord,
weeks time.
let me one
Instead,
week, my lord.
instead of the adjournment, kindly pass the necessary order, so that the purpose
Okay,
of
let
this-
let this matter on the prayer of learned advocates. The matter stands adjourned till 27/1/2026.
So far is the last part of the order. If
No,
you-
no, let it remain.
No,
We shall see on the next.
my lord.
My lord.
Grateful, my lord. My 27th, my lord. Grateful.
বিধের ব্যাপার নেই মানে গ্রেট
I am for the respondent claimants, your lordship. Lordship, on
Okay,
the-
Mr. Singh is appearing.
Mr. Singh is appearing.
Probably.
So let it be passed over.
No, my lord, she has already been concluded this matter.
Yes, concluded his.
Let Mr. Chakraborty start his argument, your lordship.
Yes.
Since your lordship, Mr. Singh's argument against Mr. Chakraborty's client, so Mr. Chakraborty first reply, then I.
My lord, in this matter, my learned friend has agitated before your lordship that they are not supposed to pay the amount, although the learned tribunal has given the direction. Both the insurance company, they are nationalized insurance company, my lord. They are supposed to pay jointly. My lord, in this connection, my lord, there is a judgment in favor of. I will not take much more time, my lord. This is a guideline.
Sir, কি নাম আছে?
এটা হচ্ছে Kenya versus New India Assurance Company Limited.
আচ্ছা।
SCC 2015, page 273.
Yes.
My lord, in the lordship may kindly come to paragraph 15. There, my lord, it is clearly mentioned. May I read out, my lord?
Yes.
There is a difference between contributory and composite negligence. In the case of contributory negligence, a person who has himself contributed to the accident cannot claim compensation for the injuries sustained by him in the accident to the extent of his own negligence. Whereas in the case of composite negligence, a person who has suffered has not contributed to the accident, but due to the outcome of combination of negligence of two or more other persons. This court in Tio Anthony versus Carbonum has held that in case of contributory negligence, the injured need not establish the extent of responsibility of each wrongdoer separately, nor is it necessary for the court to determine the extent of liability of each wrongdoer separately. It is only in the case of contributory negligence that the injured himself has contributed by his negligence in the accident. Extent of his negligence is required
Thank you,
to be determined as damages recoverable by him in respect of the injuries have to be reduced in proportion to his contributory negligence. The relevant portion is extracted hereunder, para 6 to 7. Composite negligence refer to the negligence on the part of the two or more persons, where a person is injured as a result of negligence on the part of two or more wrongdoers. It is said that the person was injured on account of the composite negligence of those wrongdoers. In such a case, each wrongdoer is jointly and severally liable to the injured for payment of the entire damages, and the injured person has the choice of proceeding against all or any of them. In such a case, the injured need not establish the extent of responsibility of each wrongdoer separately, nor is it necessary for the court to determine the extent of liability of each wrongdoer separately. On the other hand, where a person suffers injury partly due to the negligence on the part of another person or persons, and partly as a result of his own negligence. Then the negligence on the part of the injured which contributed to the accident is referred to as his contributory negligence. Where the injured is guilty of some negligence, his claim for damages is not defeated merely by reason of the negligence on his part, but the damages recoverable by him in respect of the injuries stand reduced in proportion to his contributory negligence. Therefore, when two vehicles are involved in an accident and one of the drivers claims compensation from the other driver alleging negligence and the other driver denies negligence or claims that the injured claimant himself was negligent, then it becomes necessary to consider whether the injured claimant was negligent, and if so, whether he was solely or partly responsible for the accident and the extent of his responsibility, that is his contributory negligence. Therefore, where the injured is himself partly liable, the principle of composite negligence will not apply, nor can there be an automatic inference that the negligence was 50-50, as has been assumed in this case. The tribunal ought to have examined the extent of contributory negligence on the appellant and thereby avoided confusion between composite negligence and the contributory. The High Court has failed to correct the same error. Then, my lord, 16. That the decisions in Q. Anthony and Amalfi have been affirmed, and this court has laid down that where the plaintiff claimant himself is found to be negligent, jointly and severally, liability cannot arise, and the plaintiff's claim to the extent of his own negligence, as may be quantified, will have to be severed. He is entitled to damages not attributable to his own negligence. The law distinction with respect to contributory as well as composite negligence has been considered by this court in Machinonath Kennath and versus D.S. Mailarpa, and also as to joint tortfeasors. This court has referred to Charlesworth and Pensy on negligence as to cause of action in regard to joint tortfeasors. Then, my lord, joint tortfeasors as per 10th edition of Charles of Parsi, wrongdoers are deemed to be joint tortfeasor within the meaning of the rule, where the cause of action against each of them is the same, namely that the same evidence would support an action against them individually. Accordingly, they will be jointly liable for a tort which they both commit or for which they are responsible, because the law inputs the commission of the same wrongful act to two or more persons at the same time. This occurs in cases of agency, vicarious liability, and where a tort is committed in the course of a joint act whilst pursuing a common purpose agreed between them. My lord, then paragraph 22. 22.1, my lord, page 286. In the case of composite negligence, the plaintiff claimant is entitled to sue both or any one of the joint tortfeasor and to recover the entire compensation, as liability of joint tortfeasors is joint and several. Then, my lord, in the case of composite negligence, apportionment of compensation between two tortfeasors vis-a-vis the plaintiff's claimant is not permissible. He can recover at his option whole damages from any of them. Then, my lord, these are the whole thing.
Now, what was the issue there before?
Issue was, my lord,
in the sub-state case.
lordship.
You're referring to para 15?
Head note, my lord, head note is there.
No, para 15.
Yes, para 15, 16, and 22. Then, my lord, whatever my learned friend has, as regards to enhancement, whatever he has told, my lord, I adopt the same. I'm cut shorting all the arguments, my lord. I don't wish to linger your lordship time, so that now my friend can
to see the facts. How far the facts of that case is applicable here.
Lordship. তোমার কপি দিয়েছি?
হ্যাঁ স্যার, আমি আমার পেপার পেয়ে গেছি। থ্যাংক ইউ।
এটা রাখতে পারবো।
থ্যাংক ইউ।
এটা বই থেকে নেব।
So you are relying upon this decision that in case of composite negligence, either of the wrongdoer can be sued or jointly it can be recovered.
And my lord, both the companies are nationalized insurance company. So if exchequer goes, we have already paid. United India already paid. Now it is not acceptable that both the insurance companies fight among each other.
Whether you see government or this private, all are public money.
Yes, my lord.
See, whatever it is.
Whatever it may be. So, Lord, whether they pay or we pay, that is whatever learned tribunal has asserted this, we should upheld this one. I'm grateful, my lord.
Yes, you are for the claimant.
I'm for the claimant. So, but what was the submission of Mr. Singh, your lordship? That the submission that the award is correct. There is no dispute about the quantum of the award. Now, only the argument, your lordship, of Mr. Singh that his client was directed to pay the 50%, he is not liable to pay the 50% since the cause of action arose against Mr. Chakraborty's client. Now, your lordship, this now, Mr. Chakraborty placed the judgment of Kenai, your lordship. Now, the composite negligence and contributory negligence that was settled by T.O. Antony's judgment, that has been relied upon Kenai. Now, in my client, the negligence is composite negligence. It is not contributory negligence. Now, what was the contributory negligence between Mr. Singh's clients and Mr. Chakraborty's clients? Now, Mr. Singh tried to prove that the contribution to the accident, that was Mr. Chakraborty's client. Now, here, your lordship, arising of this accident, 4 persons died. There are separate claim application laws. One of the claim application, your lordship, that was heirs of Mr. Gove, that was decided by the tribunal. There, Mr. Singh's client and Mr. Chakraborty's clients were party. In that proceedings, there was a direction for payment of 50-50. Mr. Singh's client satisfied that payment. So, with regards this payment, your lordship, I don't know, your lordship, why Mr. Singh preferred this appeal. Because already in the self-same, from the self-same accident, your lordship, from the self-same FIR, the other application that was allowed and that was satisfied by Mr. Singh's client. So, Mr. Singh's client accepted the judgment and award. Now, here, your lordship, according to Kane, your lordship, Mr. Singh,
satisfy করেছে
matter. Your lordship, I submitted, your lordship, there are other accident, other claim cases arising of the same set of accident, your lordship. So other claimants claim was satisfied by Mr. Singh's client. To say I would place that judgment, your lordship. Your lordship, this is a judgment, your lordship, arising of the self-same FIR, your lordship, the other claim case that was decided by the London trial court. And there, Mr. Singh's and Mr. Chakraborty's clients were directed to pay 50-50, and Mr. Singh's client satisfied that award. Your lordship, this is the payment made by Mr. Singh's client in that case. I've given a copy to Mr. Singh, your lordship. Now, K&A judgment, your lordship, my learned friend relied upon para 15, 16 and 22. Thereafter I will place, your lordship. Also, can you remember my client's
Yes.
heir, your lordship, the deceased? He was a passenger of the bus. That bus and the truck, there was a head-on collision. My client and other persons died. Now, all of them filed relatives of them, all of them filed a claim application. Now, all the claim application have been decided by the trial court. Now, I have given one of the judgment, Your Lordship, the other judgment also Chobi Modok case. There was the same issue, same point. And there, Your Lordship,
Another family of the, this is the victim, family members of another victim.
other, Your Lordship. So in that case also, Your Lordship, there was a direction for payment of 50-50, and Mr. Singh's client satisfied that amount. Now, Mr. Chakraborty placed the judgment up to para 21, 22, Your Lordship. I will place thereafter, Your Lordship. The Kenny's judgment.
Yes.
Self-same accident, Your Lordship.
Which paragraph? Of
Same FIR.
yes, which page, which paragraph you want to rely?
Your Lordship, para 22. Your Lordship, it is reported. The reference of the Supreme Court cases. Your Lordship, kindly come to para 22 first.
Yes.
What emerges from the aforesaid discussion is as follows. In a case of composite negligence, the plaintiff claimant is entitled to sue both or any of the joint tortfeasors and to recover the entire compensation as liability of joint tortfeasors is joint and several. In the case of composite negligence, apportionment of compensation between two tortfeasors vis-a-vis the plaintiff's claimant is not permissible. He can recover at his option whole damages from any of them. In case all the joint tortfeasors have been implicated and evidence is sufficient, it is open to the court or tribunal to determine the intrinsic extent of composite negligence of the drivers. However, determination of the extent of negligence between the joint tortfeasors is only for the purpose of their intrinsic liability, so that one may recover the sum from the other after making whole of the payment of to the plaintiff claimant to the extent it is satisfied. You see, this is my point. My learned friend Mr. Singh could recover the same from Mr. Chakraborty's client in a separate proceeding, not from this proceeding, Your Lordship. Now, in case both of them have been implicated and apportionment extent of their negligence has been determined by the court or tribunal, in the main case, one tortfeasor can recover the amount from the other in the execution proceeding. So this is not the proceeding where Mr. Singh's liability can be transferred to Mr. Chakraborty's client. Now, next paragraph, Your Lordship. It would not be appropriate for the court or tribunal to determine the extent of composite negligence of the drivers of two vehicles in the absence of implement of other joint tortfeasors. In such a case, implicated joint tortfeasor should be left in case he so desires to sue the other tortfeasors in independent proceedings after passing of the decree or award. So this is one of the judgment, Your Lordship. Now, Your Lordship, I will place another judgment of this honorable court where Mr. Singh filed the appeal. The same point was there. It is Shriram General Insurance Company versus Dhanabala Singh. This is the judgment of this honorable court. Here also, Mr. Singh's client filed the appeal. I was one of the party in that matter, Your Lordship. Here, Mr. Singh's claim that the charge sheet, though his name was in the charge sheet, but the other insurance company is also liable since the evidence against that company also. So this honorable court directed to pay the compensation what was deposited here to the claimant and to start a separate proceedings by Mr. Singh's client against the other insurance company.
And what is the point laid down in this judgment? Coordinate bench judgment.
Your Lordship,
Okay. আচ্ছা ঠিক আছে দিবি না ইনকাই ঠিক আছে Yes.
So, coming to, on relying upon this judgment, Your Lordship, my submission, Your Lordship, whatever the amount deposited by Mr. Singh's client, let the claimant be permitted to withdraw the said amount along with the interest. Now, Mr. Singh may be given a liberty to file a separate proceeding also to recover the said amount from Mr. Singh's, Mr. Chakraborty's client. This is the first submission. Now, with regard to the enhancement, Your Lordship, I have gone through my papers, Your Lordship. Mr. Singh's argument, Your Lordship, the amount actually the payment was 31,000 and the deduction was 10,000. I accept that, Your Lordship. But with regard, Your Lordship, the filial constituent to the daughter, Your Lordship,
is quantum is also under challenge.
Milord, he has filed a cross
On
objection for enhancement.
enhancement.
Cross objection means under
Your Lordship, cross appeal, I filed the cross appeal and the counter appeal, Your Lordship, for the enhancement of the award since the general PF was deducted. But after verifying that, Your Lordship, found that amount was granted, that was correct. Now, Your Lordship, with regard to filial consortium, I have taken point, Your Lordship, filial consortium to the daughter of the deceased. Now, Your Lordship judgment covered that, Your Lordship, the daughter is not entitled to the filial consortium.
no, it is the wife and the daughters have
Wife and the daughter. So, Your Lordship,
So
judgment.
your challenge is only confined to filial consortium of the daughter.
Daughter. And you'll say another point also, there's negligible amount. You'll see the general damages, Your Lordship, the as per pronunciative judgment, Your Lordship, 10% should be added in every 3 years. So pronunciative judgment was pronounced in 2017. Now this is 2026. About 8-9 years have been passed. So there may be 20 to 30% may be added with 70,000. But since you also it is negligible amount, also 14 or 21,000, I will not press that. You also. So my contention, Your Lordship, that let the my client be permitted to withdraw the amount filed before this honorable court along with the interest.
So regarding filial consortium and the other is with regard to the enhancement of
the general damage.
So how much would be enhanced according
Your
to you?
Lordship, since the
How much
daughter
is
is
the
not
general damage
entitled
awarded?
on
No, how much is awarded? 70,000?
Yes.
70,000. So 70,000 also 20% is 14 or 30% is 21,000. This is my claim now.
At best.
Because your lordship already, your lordship pronounced the judgment about the filial constitution of daughter. I will argue that in other matters. In this matter, I am not arguing that, your lordship.
Yes, anything in reply?
Yes, my lord. Lord, first of all, I give my thanks to Mr. Banerjee that he has accepted my argument with regard to the quantum. There is no dispute. So quantum, whatever has been assessed by my lord by learned tribunal, that remains. Only thing, my lord, what he has paid for the daughter, my lord has already, my lord, passed at least 10-15 judgments, my lord, where your lordship is following Pranay Sethi, save and accept one, my lord. Lordship is following Pranay Sethi, and lordship is saying that the consortium should be.
He has clarified regarding parental.
I'm extremely grateful to your lordship. I'm extremely grateful to your lordship.
Silence with regard to filial consortium.
My lord, Pranay Sethi, while dealing, my lord, with regard to the word consortium, it has dealt with, my lord, the word actual meaning, what the word consortium means. Because, my lord, there was a consortium, this confusion was there that the consortium should also be given to the other claimants. Pranay Sethi has said that no, consortium means it would be confined only to spouse. No other claimant comes under the meaning of the word consortium.
The parental consortium issue was discussed.
It was discussed, my lord. The word consortium was discussed because, my lord, the statute says that the loss of consortium, as far as the general damages is concerned, my lord, it is divided into three parts. My lord knows, my lord. Funeral, estate, and consortium. This is what, my lord, the statute is. And this is what, my lord, the Sarla Verma had given. My lord, an extended meaning was tried to be given, my lord, by some other judgments, 3 judges bench, my lord, Rajesh, Rajveer, my lord, and all. They said that no, consortium can be extended to other claimants also. Pranay Sethi, 5 judges bench, struck it down. Bolo, no, consortium means only to the spouse. No other person comes under the meaning of the word consortium. Therefore, my lord, everybody else who were there, whether it is daughter, whether it is father, whether it is uncle, whether it is a brother or sister, everybody was struck off. Thereafter, my lord, Nanu Ram, after Pranay Sethi, a division bench, my lord, said that no, we will extend the meaning of consortium again. And then, my lord, they said that no, the filial or the parental can be granted. That was followed by some other division or 3 judges bench by Supreme Court. But, my lord, Pranay Sethi is 5 judges bench. My lord, our own division bench, my lord, presided over by Honorable Justice Dipankar Datto. Another division bench presided over by Honorable Justice Shonji Banerjee, and all other single benches, my lord. My lord, I'm not talking about aberrations, my lord. I repeat, my lord, lordship, kindly pardon me. They have, my lord, in hundreds of cases have said that no, or rather thousands, my lord, that no, Pranay Sethi is Pranay Sethi, we would go by that. So, my lord, as far as consortium part is concerned, my lord, it would remain 40,000. Or, my lord, if 10% increase is granted, my lord, that 4,000 or 8,000 increases can be granted at most. My lord, in the award of 42,70,000, this 4,000 or 8,000, my lord, doesn't make any difference. The main quantum, my lord, he has accepted, and I'm thankful to that. My lord, if lordship so desires, I can read, my lord, the word, the consortium, meaning what Pranay Sethi has said.
Anyway, so let us come to this way.
Miller.
Consortium is not under
consortium is not under dispute, my lord. And my lord, the quantum also is not under dispute. Now, my lord, a cloak has been made before your lordship, my lord, or an impression has been made before your lordship by showing the judgment of Kenya that every single case where 2 vehicles are involved, it, my lord, deals to composite negligence. It's never so. Composite negligence arises only in those cases where first criteria is more than 1 vehicle is involved and both are at fault. The problem arises before the tribunal that what is the quantum of fault when tribunal does not make it out, or it is difficult for the tribunal to make out whether one is 60% responsible, other is 40% responsible, or one is 30%, other is 70%. Then Kenya comes into the picture. Otherwise, my lord, it will create, my lord, an absolute, my lord, chaos. Kenya is only for the cases when the individual percentage of negligence cannot be decided immediately. Claimant has to be given the money. He cannot sit tight that, well, who is 20% responsible because he is dead or he is maimed, my lord. He wants money. If the court sits and starts, my lord, looking into the damage part or the negligence part, one is 20%, one is 80%, or one is 50-50, he will have to wait for long. So, in order to, my lord, see to it that the claimant gets his share and claimant walks off, my lord, immediately, What Milord the Kenya says, you take your money, you are a dead person or you are an injured person. And as far as Milord, this composite negligence part is concerned between both the insurance companies, let them decide in a proceeding. That is what Kenya is. This case is not covered by Kenya. I'm thankful to my learned friend Milord for showing the Kenya. Milord, Kenya, if your lordship will kindly come to Milord, the very first paragraph, what this judgment is. Milord, it starts, Milord, this, where is it? This leave granted. Milord, lordship will kindly come, Milord, to page 277. Yes, my lord, I'm sorry.
Yes.
Page 277 is, my lord, there.
Yes.
My lord, Justice, my lord, the first sentence starts, leave granted. My lord has seen that, my lord, the very first part of the judgment, leave granted. Then your lordship will kindly see, in the appeals, the main question which arises for consideration is whether it is open to a claimant to recover entire compensation from one of the joint tortfeasors. Your lordship will, my lord, pausing here for a moment. From one of the joint tortfeasors. My lord, what is the meaning of tortfeasor? I put this question to myself. Tortfeasor is the wrongdoer. Tortfeasor does not mean mere involvement. Tortfeasor is always and always wrongdoer. Involvement does not make a vehicle tortfeasor or wrongdoer. Milord, I'm standing, Milord, and I'm driving a motorcycle. Mr. X comes and hits me. Both vehicles are involved. Am I a tortfeasor? I put this question to myself. No, I cannot be a tortfeasor. Or Milord, X is going, Milord, in the right lane in a proper speed. Y comes and hits X. Can X be a tortfeasor? No. This judgment is only confined to two tortfeasors when both the vehicles are responsible. It's, Milord, may I just read? It is whether it is open to a claimant to recover entire compensation from one of the joint tortfeasors, particularly when in the accident caused by the composite negligence of drivers. Milord, it is a case of composite negligence. That is why both are tortfeasors of a trailer, truck, and bus has been found to be 2/3 and 1/3 extent respectively. Milord, 2/3 and 1/3 extent respectively, both have been found to be negligent, rash, and that is why, Milord, this proportion was made. In what is our case, Milord? What is my case before your lordship? Milord, I have, Milord, tried very hard to show your lordship.
Is there any findings by the trial court that the accident took place due to the negligence of
the truck
of both the vehicles? Both the vehicles are impleted.
Milord,
is there any specific findings?
Milord, I had shown to your lordship, Milord.
Let us come to see two things: findings of the tribunal,
lordship,
and the evidence which you have relied.
Lordship.
That is the evidence which they have accepted.
I'll take 5 minutes of lordship, Milord. Again, just to...
examination is accepted by them. And
Yes. What more do I need to do? I'm not a tortfeasor.
Now the question is there any findings by the tribunal?
Milord, my lord will kindly come, Milord, to page number 34.
Yes.
Milord, 34 is, Milord, the quantum part. Milord, before that, Milord, I'll just indicate to your lordship. Milord, on the last date, Milord, I had shown to my lord, Milord, this page number 27. My lord had, Milord, made a mark of that. Milord, if I can recapitulate, Milord, in 2 minutes of my lord's time, so that, Milord, it would be easier for your lordship to come to particular finding why tribunal, Milord, is saying that both are responsible. Milord, I have showed my lord, Milord, the written complaint. My client, Milord, written complaint, Milord, was page number, Milord, 56 of my lord's paper book.
Yes.
My lord, perhaps, Milord, has made a mark over there, Milord. In the middle part, Milord, the active basket, jar number WB 73 is 3697, luxury bus, Barampur dik theke, Maldar dike, wrong lane, যাওয়ার একটি ডিজেল ট্যাঙ্কার যার নম্বর সো এন্ড সো বাসটিকে মুখোমুখি ধাক্কা মারে, যার জন্য ডিজেল ট্যাঙ্কারের ড্রাইভার, বাসটির কন্ডাক্টর সহ আরো দুজন মারা যায়, গুরুতর আহত হয়। মিলট, ডিজেল ট্যাঙ্কার কামিং ফ্রম দ্য রং লেন, ধাক্কা মারে। Milord, this was the written complaint I had shown to your lordship. This was the first impression. And then, Milord, I had taken your lordship, Milord, to the charge sheet. So the diesel tanker, Milord, in the written complaint was solely responsible. Charge sheet, Milord, was at page 79 and 80 of my lord's paper book. The relevant part, I had shown it, Milord. Perhaps my lord was kind enough to mark it.
Page 79.
Page 79, Milord, the last but one paragraph, starting with again. Again, is my lord there, Milord?
Yes.
Again, it is to be stated that during investigation, it is proved that for the impassive duty of NS-34 authority, the signage system was not installed properly, and this is one of the main reasons of the accident. From Ballarpur to Gholakandi, the signage system is not properly installed. As a result, some drivers inadvertently used to go through the wrong lane. The photographer took some photo of Gholakandi Mode, from where it is clear that NS-34 authority didn't install the division sign at Gholakandi Mode. So I served notice to the safety officer of this area, and he appeared before me. Then, my lord, the clinching part comes in. However, during investigation, it's been learned that the driver of the oil tanker, namely Sonu, was driving so excessive speed that he could not move for the left way and was moving through wrong lane. The accident took place due to rash driving of the driver of the oil tanker, who had died on that day. And the next para, your lordship will kindly come. Hence, prima facie charges under section so and so, which is Milord 279, rash and negligent driving, has been well established against the accused driver, namely Sonu, but not sent up him because charged it since he died. So, Milord, written complaint is there, charge sheet is there, eyewitnesses' statement, Milord, I have shown to your lordship.
Yes.
Which is at page number, Milord, it starts from 16 at 17 and 18, Milord. If my lord is kind enough to come to that. My lord, kindly, Milord, pardon me for repeating the same thing, Milord, but since, Milord, this issue was raised that whether I am a tortfeasor or not, Milord, I hit at the very root of it. I am not the tortfeasor. 17, Milord. Is my lord there, Milord? Page 17. 17 is the sole eyewitness here.
Yes.
Milord, last 5-6 lines, Milord. Milord, in the cross examination, your lordship will kindly come to in the middle part. I came to the court today. It is a fact that I boarded on the concerned bus. Milord, he was a passenger of the same bus in which victim was there. Milord, is there, Milord?
Yes.
It is a fact that I boarded on the concerned bus at Durgapur. I took the ticket in the bus. Petitioner was not present in the bus on that day. I did not disclose the entire fact to anyone before this day. Milord, I had indicated to your lordship, Milord, that this line, I am a driver by profession and used to drive vehicles, Milord, LMV. So, Milord, he knows, Milord, what is good driving, what is bad driving. And your lordship will kindly come, Milord, at the bottom part of it. I know the number of the concerned bus. The bus was running in normal speed. Milord, how can I be a tortfeasor? Thereafter, Milord, it is a fact that the offending truck dashed the bus from its front in high speed by coming from the opposite side. Milord, written complaint, charge sheet, eyewitnesses' statement, and Milord, the accident might not have happened if the driver of the truck drove the truck cautiously in normal speed. And then your lordship will, Milord, come to page number 18, Milord, moderators kindly. Page 18. Milord, cross-examination, Milord, the last part.
Yes, adopted.
Adopted. So, Milord, they are adopting whatever, Milord, in cross, the witness is saying that, yes, the truck was solely responsible for the accident. How can I be a tortfeasor? I keep on asking this question to myself. How come Kenya is, Milord, coming in here? Otherwise, Milord, every case where two vehicles are involved, Milord, it will be apportioned. No, it is never done. 1 in 100 cases, Milord, apportionment is made. 99 out of 100 cases, Milord, it is one particular vehicle. Milord, it is a case under 166. It is not 163 or 140, or even for that matter, 164. Rash and negligent driving has to be proved. to get compensation. Your lordship is well aware of that. My lord, there are hundreds of judgment on rash and negligent driving. I'm not troubling your lordship with any of those. The one who is rash and negligent will be solely responsible to make payment. Just because I was there and I was caught and you came and hit me, my lord, the responsibility will be on my shoulder. No, it can never be. This entire evidence before your lordship is that, my lord, that the bus was absolutely fine. It was correct. It was going on a normal speed. The truck or the tanker came and hit the bus from the wrong lane at an excessive speed. So why should, my lord, I be made responsible here? It is not a case of joint tortfeasors. It's not a case of Kenya, or for that matter, Dhanabala Singh, my lord, which was Sriram, which was the judgment was shown before your lordship. There also, my lord, the rash and negligent driving could not be exclusively established. Here, it is absolutely clear. It's a watertight case. Lordship. Lordship.
Regarding rash and negligent driving.
Lordship, my lord, award starts at page number. My lord, award starts at page number 19.
19.
19, my lord. And my lord, the relevant part, my lord, as far as the rash and negligent driving part is concerned, that I also shown your lordship, my lord, the written statement, so that, my lord, nothing remains, my lord. My lord, now award, my lord, at page 23, my lord, at first indication was there. May I invite my lord, to page 23. My lord, the specific line by which learned tribunal judge says that is at page 31.
Yes.
My lord, page 31 at the bottom, last but one paragraph. Lord, if my lord kindly comes to me, lord, I can just indicate why and how learned tribunal judge decided. Page 31, your lordship will kindly come to me, lord. Is my lord there? Page 31, last but one paragraph. Here in the case, is my lord there?
Yes.
Here in the case, an eyewitness was examined by the petitioner as PW3. My lord has seen that eyewitness. But the insurance companies did not adduce any witness on their behalf. There was no possibility of examination of both the drivers of the vehicles, as both died. Thus, the spirit of said observation of the Honorable High Court, Calcutta, is that it is not essential for the claimant to examine the eyewitness. Thereafter, considering all, page 32, considering all, I am of the view that the petitioners have been able to prove issues 2, 3, and 4 in their favor, to the effect that on the said date, time and place, some rash and negligent driving of the vehicles, that the truck being number so and so, bus being number so and so, causing the accident in which the victim lost his life. My lord, the crux of this finding is that the no witnesses were examined by the insurance companies. My lord, when an independent eyewitness of the claimant is there and he is saying that the truck is responsible for the accident, why any other eyewitness is required? On that pretext, my lord, the lordship will kindly come to the next paragraph, the finding. Paragraph 52. So, both insurance companies, United and New India, are liable to pay the compensation. This is how, my lord, this has been reached. The pleadings, the evidence, the written complaint, the charge sheet, the written statement, my lord, acceptance of evidence by United India that they are responsible, everything is given a go by. This is an impossibility, my lord. Everybody, everything, every single document says that the United is solely responsible for the accident. And the court says, since you did not bring any other eyewitness, that is why I will hold both the insurance companies equally liable. You know, the entire concept of 166 proceeding is given a go by. Is a case under 166. proving of rash and negligent driving is the linchpin to consider the case and to decide. I have proved that. What more am I supposed to do, my lord, in a proceeding? I asked this question to myself. The one who is rash and negligent will be responsible. United is, they have accepted themselves. Leaving aside the other my lord, clinching evidence. Why shall I be made responsible, my lord, here in this case? Lord, I humbly beseech, my lord, as far as the quantum part is concerned, my lord, is not to be touched. My lord, let the United India pay the entire compensation. My lord, let them deposit the balance amount, and I may be given liberty, my lord, to withdraw my sum, what I have deposited before my lord's court.
Yes.
Extremely grateful to your lordship.
Learned counsel for the appellant. New India Assurance Company Limited, learned advocates for respondent one, the claimant, learned advocate for respondents number 1 and 2 claimants, and respondent number 3, New India, United India Insurance Company Limited are present. Heard learned advocates for the parties. The appellant before this court was an opposite party in a claim under Section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 11/9/2024 passed by learned Additional District Judge, First Track, Second Court, Raiganj, Uttar Dinajpur, in MSC case number 2 of 2020. The respondent number 1 and 2 claimants, being also aggrieved by the said judgment and order, has filed a separate appeal, filed a cross objection being COT 115 of 2025, as well as a separate appeal being FMA 1211 2025, being agreed by the quantum of award of the learned trial court. The case of the respondent number 1 claimants before the learned trial court may be summed up thus. On 29/11/2019 at night, Polash Kumar Singho, since deceased, boarded the bus WB 73 A stroke 3697 at Shiliguri for going to Berhampur, and the bus was proceeding at a high speed and in a negligent manner. And when the bus reached at Khairakandi at about 5:15 hours, at that time another truck bearing number capital B capital R 01 dash capital G capital H stroke 5651 was proceeding from Berhampur side to Malda side from opposite side at a high speed and in a rash and negligent manner. And due to high speed and rash driving, both the drivers of the bus and the truck lost control over the bus and the truck and made a head-on collision. As a result, most of the passengers of the bus received injuries, and the driver of the bus and the truck also received injuries and at first they were taken to Tarapur and Beniagram Hospital, and out of them, the drivers of 2 vehicles and 2 passengers of the bus, that is Polash Kumar Singho and 1 girl, Deepika Modok, succumbed to their injuries. Stop. The drivers of the bus and the truck were driving their vehicles in a rash and negligent manner, and the accident took place. Stop. The deceased Polash Kumar Singho was a man of active habits, and he was the only earning source of his family, and the applicants were dependent on his income. Stop. The deceased had a chance to get promotion very soon, and due to his pathetic and early death, the applicants have sustained great financial loss and mental pain and agony, and will have to suffer throughout of their lives. Stop. Pursuant to the filing of the case, notice was issued upon the New India Assurance Company Limited, the respondent number 3 herein, the United India, New India Assurance Company Limited, the appellant herein, the United India Insurance Company Limited, and the opposite party vehicle owner. The appellant insurance company being New India Assurance Company Limited, and the respondent number 3, United India Insurance Company Limited, contested the claim case by filing written statement. Stop. Evidence was adduced, and the learned trial judge, upon considering the evidence and upon hearing the learned advocates, was pleased to dispose of the claim case by the judgment and award dated 11/9/2024 by observing and directing as follows. Eta quote, page bole dichi, quote. Page 37, para 87, গোটাটা 87.1, 87.2 till 39. The appellant, New India Assurance Company Limited, has come up with being aggrieved by the judgment and award passed by the learned trial judge, has come up with the instant appeal. The claimants, respondent number 1 and 2, also being aggrieved by the state judgment and award, has also preferred a separate appeal and a cross objection the appeal filed by the appellant, New India Assurance Company Limited. Heard learned advocates for the parties peruse the petition filed and the materials on record. Mr. Singh, learned counsel for the appellant, New India Assurance Company Limited, submits that the learned judge failed to appreciate the evidence adduced, both oral and documentary, and impose liability on his client to pay 50% of the awarded sum. Mr. Singh draws attention to the copy of the complaint made before the police authority on 1/12/2019, wherein the allegation against BR01GH56T3K is made for causing the accident due to rash and negligent driving. Mr. Singh further draws attention to the copy of the charge sheet, wherein it is stated that the driver of the oil tanker, namely Sonu Kumar Roy, was driving so excessive speed that he could not move for the left way and was moving through wrong lane. Top. And it is further stated in the said charge sheet that the accident took place due to rash driving of the driver of the oil tanker who had died on that day. Top. Mr. Singh also draws attention to the evidence of the witness of the claimants, wherein in cross-examination, the PW3 stated that he boarded the concerned bus in the night of 29/30 at Durgapur for going to Barhampur, and he is the driver by profession. Top. He further stated in his cross-examination that about 1.5 hours has been taken on that day to reach Malda by the concerned bus, and the bus took stoppage at Rathabadi More, Malda at about 1 p.m. in the night. Stop. Few passengers boarded there. The bus started running thereafter. It reached Farakka at about 2:15 a.m. He was in the accident was caused half an hour after leaving Farakka. Stop. He was in the bus at the time of accident and was sitting rearest seat of it. Stop. He also stated that the bus was running in normal speed and the offending truck dashed the bus from its front in high speed by coming from the opposite side. It is stated that the accident might not have happened if the driver of the truck drove the truck cautiously in normal speed. The opposite party, United India Insurance Company Limited, being the respondent number 3 herein, did not put anything else in the cross-examination, but simply adopted the cross-examination by New India Assurance Company Limited. Learned counsel appearing for United India Insurance Company Limited submits that as the case involves composite negligence of both the bus and the oil tanker, the learned trial judge has rightly directed both the parties to pay equal compensation. Stop. Mr. Chakraborty, learned counsel for the United India Insurance Company Limited, relies upon the decision of KHENYEI versus New India Assurance Company Limited and others, reported in 2015 9 SCC, page 273. The Honorable Supreme Court, in the said judgment and decision, while dealing with the issue of composite negligence, was pleased to observe as follows. Set out para 11 and 12, page 281. বুঝতে পেরেছেন? প্যারা 11 and 12 set out page 281. It is also submitted that the Honorable Supreme Court has observed that in case of all joint tortfeasors, in case have been impleaded and evidence is sufficient, it is open to the court stroke tribunal to determine interstate extent of composite negligence of the driver. Stop. However, determination of the extent of negligence between the joint tortfeasors is only for the purpose of their interstate liability, so that one may recover the sum from the other after making the whole of the payment to the plaintiff claimant to the extent it has satisfied the liability of the other. Stop. In case both of them have been impleaded and the apportionment extent of their negligence has been determined by the court stroke tribunal, in the main case, one joint tortfeasor can recover the amount from the other in the execution proceedings. Stop. Mr. Chakraborty further submits that both the insurance companies, being namely New India Assurance Company Limited and United India Insurance Company Limited, being national insurance, being government companies, can share the liabilities equally. Stop. Learned advocate appearing for the claimants, respondent number 1 and 2, submits that the decision of Kenai should be followed in this case, and the liability should be distributed among both the insurance companies. Learned advocate further submits that in another case where both the insurance companies were directed to pay equally to satisfy the awarded sum, no appeal is preferred by New India Assurance Company Limited. Top. Learned advocate also relies upon the decision, unreported decision of a learned coordinate bench of this court passed in FMA 642 of 2023. Upon considering the decision relied upon and the facts of the case, at the very outset, the cases relied upon does not appear to be similar to the facts of this case. Moreover, the Honorable Supreme Court, in the case of KHENYEI, SUPRA, Supra, has observed that the direction to recover from one of the joint tortfeasors can be issued when both of them have been impleaded and apportionment extent of their negligence has been determined by the court or tribunal. Further, there should be a determination of the negligence of the tortfeasors. Stop. Thus, one of the primary consideration in this issue is, in this aspect is, at the very outset, there should be determination of the negligence of both the tortfeasors. And without determination of the negligence, the liability of paying compensation cannot be imposed. Where the evidence is not sufficient to determine the negligence of either of the joint tortfeasors, liability upon the said tortfeasor cannot be fastened. Upon considering the materials on record, the evidence of PW3 in cross-examination, the first information report and the charge sheet submitted by the police authority, there is a clear involvement of the oil tanker with regard to rash and negligent driving of vehicle capital B capital R 01 dash capital G capital H stroke 5651 in a rash and negligent manner. The evidence on record does not satisfy the conscience of the court. The evidence on record does not satisfy the conscience of the court to hold the driver of the bus WB 73 capital A stroke 3697 to be negligent and to impose the liability upon the said vehicle. In the facts and circumstances, this court is of the view that the liability to pay equally upon both New India Assurance Company Limited and United India Assurance Company Limited should be modified. Thus, with regard to the cross objection about the quantum of compensation, this court is of, and the separate appeal filed by the claimants, this court is of the view that as the compensation awarded is just and reasonable, there is no scope to interfere in the compensation awarded. Thus, this appeal FMA 642 of 2023, along with FMA 1211, FMA 304 of 2025, along with COT 115 of 2025 and FMA 1211 of 2025 stands disposed. The award, judgment and award of the learned additional district judge, first track, second court Raiganj, Uttar Dinajpur, in MSC case number 2 of 2020 stands affirmed so far the compensation is concerned. However, the direction upon both the insurance companies stands modified to the extent it is hereby directed that the United India Assurance Company Limited shall pay the entire awarded sum along with interest as directed by the learned trial court. Such deposit shall be made within 8 weeks from the date of communication of this order. Upon the deposit being made, the claimants, respondent number 2 and 3 will be entitled to withdraw the awarded sum upon compliance of the formalities, and the appellant, New India Assurance Company Limited, will be entitled to withdraw the sum deposited by them.
Along with all accrued interest.
Along with all accrued interest.
Your Lordship,
Grateful to your Lordship.
the balance amount along with the interest, Your Lordship, otherwise the interest would not be granted.
No, I have recorded as directed by the trial court.
Your Lordship, unless Your Lordship
No,
clarified that, Your
whatever.
Lordship,
Okay, as directed by the trial court along with interest.
along with
Whatever the
interest
trial
at the
court
rate of,
directed.
Your Lordship, along with interest,
As directed by the trial court is very much sufficient.
Your Lordship, only line, Your Lordship, from the date of the filing of the application till payment.
That is the direction of the trial court.
Your Lordship, kindly modify that, Your Lordship, otherwise they will not pay, Your Lordship.
The respondent number 1, United India Insurance Company, is directed to deposit the balance amount of the awarded sum along with interest as directed by the learned trial court from the date of filing till to date.
Your Lordship.
তারপরে যা আছে such deposit shall be made within 8 weeks from the date of communication of this order. তারপর যা withdrawal যা আছে তাই থাকবে।
Obliged to my lord.
ঠিক আছে।
তুই নেই, আমি যখন ঢুকছি যখন আছিস তুই।
আমি আপনার একটু সব
এটা কার কাগজ রে? ক্রিমিনালের কাগজ। এই কার কাগজ? জাজমেন্ট।
ফিক্স ম্যাটারটা টেকে দিন কোথায়?
হ্যাঁ টেকেছি। বলো এটা very short point. We are consuming. I am for the petitioner.
No, which item? That is 8.
8.
Which for the opposite respondent?
আছিস বাবা?
Your Lordship, item number 8, for the Union of India, Mr. Dao is appearing for Union of India, Your Lordship, and he is in an emergency situation and admitted to hospital today only because of his dental surgery. Kindly taken it after 2 weeks, my lord.
I'm just making it not this week. If the next week you have some difficulty, you come. Okay, not this week.
আগে বলতে পারিস না?
এক্ষুনি আমি
This is
জানতে পারলাম,
this is very bad.
হ্যাঁ এক্ষুনি
Why
জানতে
did you intimate earlier? Okay, not this week.
Yes, yes. হ্যাঁ, এটা বলে দিলেই হয়।
item number 21. I appear for the
My lord,
yes.
My lord, the short point involved in this matter is, my lord, there was 2 claim cases, my lord, filed before. Actually, what has happened is the consignment was booked by IOCL of naphtha and it was transported through railway. And railway has charged 20% surcharge on transportation of naphtha. Now, my lord, there was a notification in 2007, and as per that notification, my lord, transportation of petroleum products surcharge was withdrawn. Levy of surcharge was withdrawn. Now, the short point involved in this matter was whether as per the notification will be applicable of this 20% surcharge being levied
before the division bench.
It was before the division bench. There was 2 appeal from the Railway Claim Tribunal. Now, one of them has been disposed of, holding that the circular is applicable in this case. But I was just humbly praying before your lordship, may this appeal be also be disposed of in terms with the one which has already been disposed of, my lord.
Let us see the facts of the case.
The same, my lord, same. 2 consignment was booked on that day, and in both the consignment, 20% surcharge was levied.
What is the order under appeal?
My lord. My lord, kindly see the memorandum of appeal, my lord.
Okay, তো কেন আমাকে দেয়নি? কোর্টে 2টো আপিল আছে? দুটোই হাইকোর্টে হয়েছিল। একটা কি ছিল অর্ডার? একটা ওই সার্কুলারটা অ্যাপ্লিকেবল হচ্ছে। হ্যাঁ হ্যাঁ, আপনার ক্লেম নাম্বারটাও দুটো এক, 34 আর 39।
That be, but in this case, my lord, that is not.
My lord, may kindly see the order passed by the division bench of this high court in the other appeal, my lord.
See the order passed. Let us see the facts of the
My
case.
The facts are absolutely same, my lord.
এটা ম্যামকে পাঠিয়েছিল।
হ্যাঁ, এটা আমার কাছে আছে, কিন্তু এটা কি আপনাদেরই মামলা? আপনাদেরই মামলা?
হ্যাঁ, ওই ক্লেম
কত? 34, 35?
তো হ্যাঁ,
35 এর?
35 এর। এটা 34, এটা 35।
35 তো টাকা দিয়ে দিয়েছে।
35 টাকা দিয়ে দিয়েছে, বাট দুটো সেম কেস তাই। দুটো অ্যাপিলই তখন ফাইল হয়েছিল।
তোর আমার 35 এর অর্ডারটা তারপর আমাদের ধরেছিল নিয়ে তো অর্ডারটা আছে না, এই অর্ডারটা হচ্ছিল যে এটার অর্ডার একটা হচ্ছে দুটো করে কোর্টের অর্ডার অনুযায়ী কোর্টের অর্ডার বললেও যেটা করেছিল দেখছেন কি ওদের আর কোনো বক্তব্য নেই, ওরা যা বলছে
So the question is, it is for the realization of
Well, whether the 20%
that is
surcharge,
railway receipt charges.
that is applicable or not. That is the question, and whether that circular under which the surcharge has been withdrawn is applicable or not. That is the notification of 16th of October 2007. My lord, 2 consignment was booked within that period, and in both the consignment, my lord, surcharge was levied. 2 claim cases was filed before the Railway Claim Tribunal. One of the claim case is 34, another was 35. In both the claim cases, the tribunal has passed on the same date this judgment, my lord. From both the judgment, my lord, 2 appeals were filed before this honorable court. One of them has been disposed of by the honorable division bench of this high court, holding that the surcharge which has been levied by railway is illegal, is wrongful. My lord, I am just handing over the copy of that judgment, my lord. This is claim case 35, my lord, and this one, the claim case is 34, my lord. The same facts and circumstances, same within the same period consignment was booked, same consignment, and the honorable.
may I submit?
Yes.
My lord,
And on the basis of that judgment, my lord, they have paid entire 1 crore something, my lord. The respondent had already paid them 1 crore something, whatever was the claim. But my technical problem is that, my lord, they have filed 2 cases, 34 and 35, on the same date, and in 35, entire payment was, my lord, given. But they are in 34 matter, my lord. But the
Now
problem
this is which case?
This is 34, my lord. 2 consignments,
my
2
lord.
separate claims,
No,
my
no,
lord.
2 judgments you are relying upon. In one has been disposed
One has been
by
disposed.
the division bench.
Payment has already been made, my lord.
Okay, the other is before this court.
Before
Yes,
this court, my lord.
So you are relying upon 2 disposed judgments.
One disposed judgment, my lord.
One
This is
disposed judgment.
37.
37.
Yes, my lord.
Okay, so one is disposed, and you have received the entire sum.
In respect to
Entire sum.
that claim, my lord.
Yes.
That claim. The problem is that my technical problem is that it is bar, my lord, under my lord order to rule 2, my lord, because
they have to, my lord, claim in a single, my lord, case. Splitting the, my lord, two cases and claiming two, my lord, things, my lord, is not permissible, my lord.
But this point was
And
never raised
before
before the
that, my
railway
lord,
claim
leave
tribunal.
has to be given, but they have not taken, my lord, any
This
leave,
point
my
was
lord.
never raised
Your
before
lordship,
the.
policy order
There was two separate claim cases.
Yes,
Right,
my lord.
Two separate consignment, my lord.
Filed simultaneously.
Let
And
us see the provisions of that act, Railway Claims
yes,
Act.
my lord.
This is the Railway Claims Act.
No, my lord. Order to
No, the act is the
CBC, my lord.
statute. Let us see the statute. No, this is railway.
In
This is
statute, my lord, that is not there, my lord.
And in the statutes, there was no
They have
such thing.
they have filed my the affidavit in opposition. That in affidavit in opposition, this point was
okay,
taken,
this
my
is,
lord.
application under 16 of Railway.
160 of the Railway Claims
16.
Tribunal. 116.
Your lordship, kindly see page 9 of the paper book. Page 9 of the paper book.
Yes. No, what is the findings of the tribunal? You just
The finding of the tribunal is,
my lord, rejected as per the, my lord.
because the circular was not provided, the tribunal has hold it is the burden of proof on the claimant to provide the circular, and in terms of that, it has been disposed of. Well, the division bench has hold that it is the duty of the railway to provide the circular. My lord, I can show it from the judgment, my lord, the relevant paragraph.
That is how the as per the, my lord, order, my lord, they have complied the order and paid entire thing.
My lord,
But
there
my
was-
lord, this case is for the, my lord, interest and lawyers.
No, my lord, no, my lord, no.
8 lakhs
My lord,
something.
kindly see, my lord, kindly see.
It's technical issue, my
It
lord.
is two separate
how much
consignments.
claim you have made in this case?
But in this case, 8,67,595.
For
There was
interest and lawyers.
well, there was two separate
Litigation
claims.
charge.
There was
This
two
is-
separate
this is,
claims.
No, this is a liquidated claim, not unliquidated.
Liquidated claim, my lord. In two
Liquidated
parts, my lord. That
And
cannot be possible.
This amount has been deducted.
Order to rule
This
two, my lord.
amount has been deducted as surcharge, my lord.
Unless
There is
they
no
have
advocate
taken
fee
the
here
permission.
which is involved.
Leave of the court, my
So
lord.
it's better if both of you come with written notes of arguments on the next day.
My lord,
My lord.
this matter can be disposed of, my lord, in terms of the judgment passed in a similar set of matter.
Consider the judgments. Let your learned friends also come with arguments.
And I am already provided in
My
the
lord,
judgment.
we have already, my lord, submitted affidavit in opposition, my lord. In affidavit in opposition, my lord, that points were, my lord, taken, my lord.
My lord, then kindly fix the date. I will come up
This
with a
is
written
not a
notes of
question
argument.
of fact, okay? Whatever is there in the
Technical, my lord, only
no, in the paper book comprises of entire evidence, I think.
No, my lord. Affidavit in opposition is there, my lord.
My lord, only
Lord,
question
kindly
is whether
see-
this circular is applicable or not.
Application.
We have already submitted affidavit in opposition. If your lordship writes, we can also file, my lord, written notes of.
Okay, file your written notes of argument. I shall dispose it on the next day. Yes.
My lord.
My lord.
Learned advocates for the parties are present. Hard learned advocates. Hearing the learned advocate. This court is of the view that the parties should be granted opportunity to file written notes of arguments. Thus, the written notes of arguments be filed. How much will you?
My lord, within a week I will file it, my lord.
Of arguments be filed
Weeks, no.
on 21/1/2026. Let this matter appear.
My lord, one matter is fixed, my lord, 21. 20 after, my lord, the vacation, 4 days vacation.
My lord, it's a very short matter, my lord, before the vacation, my
27.
lord.
27, my lord.
27/1/2026 as to be mentioned.
My lord.
My lord, fixing a 27th.
Yes.
27/1/2026 as to be mentioned. File your written notes of
My lord,
argument.
my
My
lord.
lord. नाम दे दीजिए। हाँ, नाम दे दीजिए। नाम दे।
22, may I please, your lordship?
For the alleged contempt.
This is the service, affidavit of service I have served. Till date, your lordship's order has not been complied with.
Well,
Yes. What
there
is
is
the
one thing, my lord. Possibly the officers have changed. Shri Shailendra Uttam in place of the first contender, my lord. প্রিয়াঙ্কা বাসু তো কন্টেম্পট
নিয়ে নিয়েছে সার্ভিস নেবে অ্যাকসেপ্ট করে
তার উপরে
Yes,
প্রিয়াঙ্কা
what's
বাসু
the order passed?
Your lordship pass an order, my lord, kindly come to page
310.
yes, my lord, page 18 is the operating part. Page starts
the
from
contempt first has to be served on the contemptor. I am saying well, Priyanka Basu, the contempt
page
number
18,
1.
upon consideration of
Contempt number
election.
is no longer there. Shri Shailendra Uttam is now in that post and contempt number 3.
The occurrence took place during his tenure.
Yes, my lord.
So he has to be there.
But the
And she
present incumbent has also to be.
Yes, incorporated
no,
subsequently.
the subsequent officer has also to be incorporated and served.
That is why the present incumbent
Yes, present incumbent will incorporate.
Has to be
My lord,
incorporated.
kindly
Yes,
have a
I
look.
got an order. Learned advocates for the parties are
My lord,
present.
in the meantime, they will comply, file
My
a
lord,
report
my
for
lord,
compliance.
several appeals have been
My
filed.
lord,
Okay, learned advocates
No.
That I will
for the
make my submission.
parties are present. Learned advocate for the contender submits that the
Contempt number 1
contender number 1
and 3.
One and 3 are no more in office. And at present, who is there in the office?
My lord, contempt number 1 is Sri Shailendra Uttam.
No. Contempt number 1 is MS Priyanka Basu.
No, in her place, Sri Shailendra Uttam has come.
No. Whatever it is,
either
you see.
4 number or 5 number.
If the
Yes. Then Shailendra Uttam and
the-
Sanjay Yadav.
The present incumbents are Sri Shailendra
Uttam,
Shailendra
UTTM,
Uttam and
Sanjay Yadav.
Sanjay Yadav. Let the present incumbents be impleaded in this contempt application and notice be served upon them. Let this matter appear on 31/1/2026.
My lord, in the meantime, they will comply with it.
In the meantime, steps shall be taken by the contemptors to comply the said order.
Much of
Then my submission may also
In the event
they have
there is
not
no
been-
order of stay obtained from the appeal court.
much obliged. Grateful to you. That's
25 ke ache 25.
My lord, 22, 23 and 24 are same.
31 আচ্ছা 30 করে দিন 30th
30th, huh?
But
30.
not 31 30th
30 first.
all three matters, my lord.
it's all same order. No, same persons.
Persons are
So same order.
30th, my lord.
Yes.
22.
No, Pochish has not yet been served. This is first time. Your lordship may direct me to incorporate the present incumbent as a contemptor and serve the copy to the
Yes, call
all the
25.
contemptors. 25 I am for the petitioner. My lord, your lordship's order is page, my lord. Page 25. And operating portion is page 26. Yes, continue. Page 25, your lordship's order dated 3rd October 2025.
Yes, learned advocate for the petitioner is present. This application is directed on the ground of alleged violation of the order dated 3/10/2025 by the alleged contender. Thus, notice be issued upon the contender respondents, an affidavit of service be filed. Let this matter appear on
30th
1/2026.
Much obliged, my lord. The contempt number 3, as my learned friend
Will
indicated.
come with necessary applications. If
My
you
lord,
want,
if your lordship grant me leave to incorporate the new incumbent who is holding that post, I can implement.
the petitioner may implead the new incumbents
Of contemptor number 3.
who are in charge of the office of the contemptors by taking out necessary applications.
My lord, application is not required.
Otherwise,
Your lordship may give a leave.
The question is, you first serve, okay, on the next day I shall see.
Yes.
It's better
Then
than
they
instant-
come and
Yes,
say
yes.
that much obliged.
Second
Much-
take it in second line.
Grateful to Lordship. And আমি কারেকশনটা করে দিচ্ছি।
My lord, I am for the appellant.
26, my lord, I am appearing on behalf of the respondent insurance company. My lord will kindly take up this matter day after tomorrow, my lord.
Not today, tomorrow.
I'm grateful, my lord.
My lord had been fixed for hearing.
These applications are to be taken up. There are some applications.
Application may be disposed of. She told.
15th. আজকের কাজ? I'm grateful. my lord.
My lord, item number 61. My lord, one thing I may mention, item number 61 not this week, but earlier week also said this week. Again this week, not this week. Item number 61. 61.
Okay, let it be
It will go this week. Last week, my lord says that wrongly it was recorded.
Item 61.
61, yes, my lord.
61.
Ah,
Yes, my lord, on last Friday, my lord, matter has appeared, my lord, as to be mentioned. My lord, first your lordship kindly take
What is
the
this
my
application? What application?
application for recording the date of the applicant number 3.
That application has not come in the list.
Yes. Yes, my lord, that and the my lord, the 2 PR my lord I made that recording the date of applicant number 3 Shukla Mojumdar, who died intestate on 4/3/2004. That man I have annexed the death certificate.
That
And
is
for
the death of which appellant?
applicant number 3
The Shukla Mojumdar.
Shukla Mojumdar.
The
that-
years are already on record.
Yes. And my lord, and the recording the attainment of majority, applicant number 2, who is the minor daughter of the disease, the Kumari Shreya Mojumdar. Now, my lord, and also, my lord, I pay, my lord, amendment or spelling of title. My lord, Mojumdar, my lord, from the Aadhaar card, it appears Majumder. But my lord, in the memorandum appeal that I have annexed, my lord, the Aadhaar card. Memorandum appeal.
It is MAZUM.
MAZUMDER in the memo of appeal.
But in this application, it is MAJUM.
Yes. MAJUMDER. DAR. It should be DAR.
Okay.
টেবিল করনি
হ্যাঁ করেছি তো।
টেবিলটাকে খুলে দাও না টেবিলটা তুমি দেখো তোমার
হ্যাঁ, টেবিলটা করি।
Yes, record and order. Learned advocates for the parties are present. This application is directed for recording the death of appellant number 3, Srimati Shukla Mojumdar. It is the contention of the appellants that the appellant number 3 died on 4/3/2024, leaving behind the applicant number 1 and 2 being the appellant number 1 and 2 as legal heirs. Stop. As the heirs of the deceased appellant are already on record, let the name of the appellant number 3 be deleted from the cause title. Stop. The appellants have further made a prayer that the name of the majority of appellant number 2 be recorded. The appellants have relied upon the Aadhaar card of the appellant number 2. Stop. It is also contended that the name, the surname Mojumdar be corrected instead of MAZUMDER, it be rectified as MAJUMDER. Stop. Thus, this application stands disposed. The department shall carry out the amendments within a period of 2 weeks. Liberty to mention.
My lord, one thing, my lord, this appeal, my lord, only 2 points. This is my lord, general damage, my lord, and also
Okay,
future.
after 2 weeks, let it be corrected. Thereafter, let it appear. After
My
2
lord,
weeks.
kindly fix a date.
Yes, yes, after 2 weeks. Liberty to mention.
No mention again. Liberty to
My
mention.
lord, kindly returnable date kindly mention. My
I
lord.
think amendments will carried out. Okay. After it is carried out, you mention. If it is carried out within 1 week, you mention.
My lord, it was mentioned, my lord, the file has been pursued and then
No,
come.
no, this matter, it is for the first time direction is being made.
Matter, your lordship, kindly, matter will appear as hearing. My lord, kindly, matter will appear as hearing after 2 weeks.
No, no, liberty, I am granting you liberty to mention.
For
whatever is the stage you mention, first of all, it will appear as to be mentioned, thereafter hearing will be fixed. Yes.
I am for the petitioner claimant. Lordship,
Paid by Mr. Rohan Banerjee, my lord.
Lordship, in this matter,
What is this scan 7?
scansible for correction in the name of claimant number 4. Lordship, the matter with the appeal court, judgment was passed, but after contacted with the claimant, petitioner change her, that's mean claimant number 4 change her name from as Dixit, DIXIT.
Yes, you take instructions.
My lord, I have, the matter was disposed of, my subsequently, we have deposited the amount before the learned registrar general, my lord. Subsequently, they have made this
You are for
application.
the South SBST.
Bengal State Transport, because we don't have any instruction regarding, because,
Okay.
but my
Now the
lord,
question is some names of the
yes,
because of the
only thing, my lord, during pendency of the appeal, we have deposited, they withdrawn 50%, my lord,
yes.
in the same name. That is the Moushumi Dikshit Orao. And subsequently, previously an order was passed for giving them 2000 rupees, and we have given the check on the same name. Recently, they have taken this application on that ground.
This is the application you have filed.
Yes. Can 7. They want to change the name Moushumi Dikshit Orao to Moushumi
Actually,
Dikshit.
there is a spelling mistake like DIKSHIT. But after marriage, her name was changed as DIXIT.
After marriage, the surname change.
No, I mean surname change. She changes the spelling.
Because this is the check, previous check, my lord, they have received.
Question is, now this instead of Moushumi,
Mousumi Dixit Odam will be corrected as Mousumi Dixit, DIXIT.
that Oram has to be deleted.
Odam has to be deleted, and the spelling of
Any documents in support of that?
Yeah, annexure number P2, my lord. P2 passbook and
Question is page 16 is what? Voter card.
Yes,
Voter card
voter
is
card.
prior to marriage.
Yes, lordship.
In the, it was mentioned.
Kindly see page 17, lordship.
Page 17.
Aadhaar card.
Aadhaar card.
Moushumi Dikshit.
DIXIT.
Acha, so
as
it is,
per
it is DIXIT. Why you want DIKSHIT?
No, as per the memo of appeal,
yes,
the name was written as Mousumi DIKSHIT Odam. Mousumi Dixit Odam. So as per the now the name was changed, surname was changed as Mousumi Dixit. In passbook, it is written as Mousumi Dixit, DIXIT. So this is the issue.
So it is written as DIXIT.
Yes, lordship.
But you want DI.
No. I
What you have made a
DIXIT.
prayer. You have made a prayer from Mousumi Dikshit Orao.
Yes, lordship.
Yes, record an order. Learned advocate for the parties are present. This application is for recording the correction in the name of the claimant. It is the contention of the appellant claimant Mousumi Dixit that her name be rectified as per the Aadhaar card and bank passbook and made MOUSUMIDIXIT instead of MOUSUMIDIKSHITORAM. Let the necessary rectification be made. The department is directed to carry out the rectification within 2 weeks. Upon the correction being made, the claimants are entitled to withdraw the awarded sum deposited after compliance of all necessary formalities. Disposed.
Can dispose.
In matter to dispose of it.
Okay. My lord, this is insurance company's appeal. My lord, this matter is ready for hearing, my lord. It was appearing under the heading hearing, my lord.
So these applications are to be disposed, can 1 and can 2.
Yes, it was for stay, I believe.
No, one is for withdrawal, my lord. But on the last occasion, my lord, the claimant's advocate submitted that if the matter is heard on the merits, my lord, then the entire matter.
Can 1 and this can 2 is for?
Can 2 is for withdrawal, my lord. Can 1 is for stay, my lord. We have already deposited the amount, my lord.
And there is another appeal taken out.
Yes, it is arising out of the same accident.
By another claimant. This is the appeal by another claimant.
Another claimant, my lord.
Arising out of the
Same accident.
That's why both have been tagged together by a previous order.
Yes, record an order. Let this learned advocates, paper books have been filed.
My lord.
Learned advocates for the parties are present. As the appeal is ready for hearing and the paper books have been filed, let this matter appear for hearing on 20th January.
20th.
20.
My lord, can it be done after that week, my lord? Kindly, my lord.
27,
29th, any date, my lord.
28,
Yes.
1, 2026. Yes, 28/1, 2026.
My lord, with regard to item number 30, I am submitting the paper book today.
Item number 30, learned advocates for the parties are present. Let the paper books filed be kept with the record. Let this matter appear on 28/1, 2026.
Grateful, my lord.
Both these matters.
Yes.
একসঙ্গে আছে পেপার বুক দুটো আলাদা হবে
Order accepting.
I'm for the respondent in this case, Millet. What I'm praying for not this week.
I'm praying for not this week.
Okay, not this week.
33, my lord, I am appearing on behalf of the appellant insurance company. It's coming up for the first time for stay. Difficulty, my lord, I'll be candid before my lord. I had served the
Section 5.
Section 5. I have served both the applications as well as the memo. But I've lost that postal receipt. But this service upon the owner, my lord, it has come back. This envelope, it has come back. Yes, I have served everybody, but since I've lost that postal receipt, that is my only difficulty. What I pray before my lord will kindly grant me interim stay. I shall serve once again afresh. And I
record an order. Learned advocates for.
And I've also deposited 25,000.
Okay, that you have deposited. So there is an interim order is there. It's
no 25,000. The statutory deposit I have made. Now I'm praying for before my lord to deposit the
advocate for the appellant insurance company is present. The appellant insurance company is directed to cause service of the application under Section 5 of the Limitation Act upon the parties. Let this matter appear on 27/1/2026 as the matter is sub judice before this court Parties may seek adjournment before the learned trial court, stroke executing court, which may be considered.
My lord, 27th.
27.
20. My lord, we'll fix it before that, my lord. I'll do it by this week only.
Anyway, just wait. You obtain the track report, come ready.
My lord, my lord. Grateful, my lord. তাহলে ওটা ওই মেমোটা নিয়ে নি না ওটা না, ওটা আমি কপি দিয়ে দিচ্ছি
34. Yes, not today.
35, my lord. I am appearing on behalf of the appellant insurance company, my lord. There is only stay in this matter. I've deposited 25,000.
Yes.
This is the
record to the Yes, record and order. Learned advocate for the appellant insurance company is present as the appellant. Just a minute. This is FMA for 547 on 25/8/2025.
my lord. FMT MV 547.
FMAT 547.
My lord, MV.
Yes, Oriental Insurance versus Jahina Bibi.
No, National Insurance versus Juma Singh.
This is a different. এটা অন্য ফাইল দিয়েছেন।
Oh, that is the last matter, item number 34, that file.
পরেরটা দিন 35টা দিন।
ওই চালানের কপিটা তাহলে বোধহয় এর মধ্যে ঢুকে গেছে। চালানের কপিটা।
Yes, record and order. Learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an interim order of stay of the judgment and award dated 15th day of September 2025, passed by learned additional district judge, First Court, Alipur, South 24 Parganas, in MSC case number 226 of 2019 for a period of 5 weeks. The appellant shall take steps to deposit the entire awarded sum as directed by the trial court, including interest, less the statutory amount within the period of 5 weeks. Stop. In the event such deposit is made within 5 weeks, an interim order of stay shall continue till disposal of this application. Liberty to mention.
My lord, and Registrar General to invest the amount.
The Registrar General is requested to invest the sum deposited in a fixed deposit of a nationalized bank.
My lord.
And renew the same from time to time.
My lord, I'm deeply obliged, my lord, extremely grateful.
Lord, 36 is the insurer's appeal appearing for the first time before your lordship. Lord, I have made the statutory deposit of rupees 25,000 and I was praying for interim stay.
Yes, it is within the period of limitation.
Yes.
Yes, record and order. Learned advocate for the appellant is present as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an interim order of stay of the judgment and award dated 12th day of September 2025, passed by learned judge, bench 11, City Civil Court at Calcutta, in MSC case number 280 of 2016 for a period of 5 weeks. Stop. The appellant shall take steps to deposit the entire awarded sum within the period of 5 weeks, along with interest. Deposit the entire awarded sum, including interest, as directed by the learned trial court within the period of 5 weeks.
Lord, let's statutory.
Excluding the statutory amount.
Grateful to my lord.
In the event the amount is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General is requested to deposit the entire awarded sum in a fixed deposit of a nationalized bank and renew the same from time to time. Okay, liberty to mention.
Extremely grateful. My lord, at 2 o'clock, your lordship has got one writ hearing, and my lord, then 3 o'clock, my lord has got original side matter. So, my lord,
Probably the MSCC matters cannot be taken up today.
extremely grateful to your lordship. I'm obliged.
My lord, the very next matter, my lord, I'm
Both of us are here.
Well, I'm praying for my lord 2 weeks time, my lord, to file my opposition. My lord,
This can one.
Can one.
Can one.
That's my stay application. Stay was granted by the Honorable Division Bench when the appeal was getting admitted and time to time extended by Lordship.
You are for the appellant.
I am for the appellant.
So you want your learned friend wants to file opposition.
Yes, my lord.
Yes, record an order.
Just 2 weeks time, my lord.
Learned advocate for the parties are present. Learned advocates for the parties are present. Time to file affidavit in opposition to Can 1 of 2022 stands extended for a period of 2 weeks and reply, if any, within 1 week thereafter. Let this matter appear on 4/2/2026.
Then the interim order was still
Interim order of stay granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
Well, in very next matter, my lord, I am for the appellant. The section 5 needs to be served upon the respondent. If order be passed, my lord, I am served.
Okay, I'm just making it not this week. You serve and come.
My lord, one direction, my lord, one direction.
No, it is a rule. You don't require any direction. Section 5 has to be served.
No,
For
this is
that-
appearing for the first time.
Whatever it is, Section 5 has to be served.
My lord, pass.
Acha, ওটা করে দিন তো।
Very next matter, item number 38.
Learned advocate for the appellant is present. Let copy of the application under Section 5 be served. Let this matter appear on 27/1/2026.
Grateful. হ্যাঁ দিয়ে দিচ্ছি।
Call the fifth matter.
সিদ্ধার্থ দা এই কম্পাইলেশনটা জজ সাহেবকে দাও করে দেখাই kindly take this compilation that I have made for your lordships. এই কম্পাইলেশনটা তোমাদের কাছে সবার কাছে দিয়ে দিচ্ছি আছে মানে সব কাগজগুলো রিলিভেন্ট গুলো Lord, on the last occasion, I was addressing your lordships, Lord, on the point to show that the entire approach was malafide. Lord, just for your lordship's recollection, Lord, may I take 2 minutes of your lordship's time? Lord, Lord Ardhendu Mal, he committed suicide, Lord, on 4th September 2024. And Lord, on 7th September,
Yes.
Lord, there are 2 documents I handed over. One is this list of documents and the other one is identity of the parties.
The
That's
compilation, which
one compilation, one is identity of the parties with a list of date, which is these 2 documents. Kindly take the Lord, the thinner one. এইটা দাও সিদ্ধার্থ দা একবার
পাতলা করে একটা স্পাইরাল আছে
একটা পাতলা স্পাইরাল আছে এই তো তোমার দিয়েছি লিস্ট অফ ডেট একটা Lord, kindly take page 8 of that document once.
Yes.
But what I have argued on the last day, I'm just giving you lordship's note for your lordship's kind recollection. Lord, kindly take on 4th September 24, Ardhendu
Yes.
Mal arrived outside the petitioner's residence intending to proceed with the banking task, home loan. However, he left after a brief visit. Then, next entry, 4th September, later on that day, Devobroto Bag came to know that nephew of Ardhendu Mal said Ardhendu have tried to commit suicide by consuming poison. And Tumpa Mal and her associates took Ardhendu Mal to the hospital, which is 22 kilometers far from the area, by a Toto. After that, Devobroto called one chauffeur-driven car, being number so for taking Ardhendu to the hospital. So on that day, Ardhendu committed suicide. Can you turn the page? Page 10. I'll not trouble you also with the other facts. 7th September, Devobroto, suspecting foul play surrounding the death of Ardhendu, filed a complaint. So, Lord, the first complaint was from Devobroto, alleging that Ardhendu committed suicide because his wife was having an illicit relation.
Yes.
So, Lord, kindly take the next. So, this is, my Lord, my Messi on 7th September, WPA 27074 was filed by Devobroto for registration of the FIR on his complaint. That is also pending before my Lord. Okay. 27074 has been filed by Devobroto seeking registration of the complaint. Lodged by him, that's the first in time, 7th September.
Then we are calling the next entry, 9th September, respondent number 5, main agents, hooligans came to the petitioner's residence, demanded 15 lakhs protection money to be paid to the local Trinamool Congress party officer, Jela Porishod member, so-and-so, respondent number 13, Nirmanendu Roy 9, and threatening consequence if he refused, petitioner refused to comply, resulting in high-handed tension. 10th September, petitioner's wife lodged a complaint to the Sampur police station through email and via post and lastly via telephone with regard to the forced eviction and threats of blackmailing for the money. Now, this was the writ petition 23635. This is filed by Gopa, Devabrota's wife. My lord will get that, not in the next page. 13th September, Gopa filed the writ petition. Then, my lord, the matter was taken up by my lord Justice Rajashri Bharat.
First writ petition by?
First writ petition is by Gopa.
No, 27024.
No, Lord, if we see the writ petition number, the first writ petition number is 23635. That is filed by Gopa on 13th of September because on 10th September their houses were attacked.
13th of September 2024.
Yes, page 12. That's the first writ petition.
Yes.
Then the second writ petition, my lord may take note, 27024, that is filed by Devabroto seeking registration of FIR on his complaint, which he made on 7th September.
This is the second one.
Second one, filed by Devabroto. That was the first complaint that Ardhendu committed suicide because his wife having an illicit relation.
Regarding this attack on the house, this is 13/9/2024.
Yes, that's the only writ petition regarding attack on the house.
Devabroto.
That is filed by Gopa, 23605.
Yes, and by Devabroto.
27024, that is for seeking registration of FIR.
Date?
Lord, that was filed on page 14.
8 November.
Lord, 8 November, page 14 kindly comes. 8 November, he filed the writ petition.
8/11/2026.
Yes, yes.
Okay, now the question is, after how many days from the date of the suicide, the present FIR?
Yes, my lord will get that. My lord will get that in page 12. Page 12 of the list of date.
Page 12.
16th September, 4th September date of incident, 13th Gopa approaches writ court, immediately thereafter counter blast.
16/9.
16/9. And that FIR has been challenged by
The incident date is
4th September. 4th September. That is not at page 8 of the LOD. My lord, kindly allow Mr. Edulji to take over. My lord, he is leading me. My lord, I'll come back in 2 minutes. I'll come back.
yes. Yes.
But subsequently to the filing of the first writ petition, it came up before this honorable court on the 1st of October 2024, that your lordships will get at page 13. When it was brought to the notice of this honorable court that no steps were taken with regard to the complaint filed by my husband But as a counterblast after filing of the writ petition, this particular FIR was lodged. This honorable court was pleased to direct that no coercive steps be taken against the petitioner Gopa Maiti.
My lord, regarding the affirmance and submission made by my learned friend,
Yes.
that no coercive measure will be taken
Yes.
by the Honorable Justice of Honorable Court. Now, this myth has been broken by Honorable Justice also, Supreme Court of the Apex Court.
The
Their
question is
lordships.
that this order is still in existence.
My lord, I'm talking about in general of what Apex
No,
Court.
no. Question is the order still in force?
My lord has this has
My lord, warrant was issued against
My lord
the
has-
accused person. Charge sheet submitted.
Submitted.
They have not took any bail.
Why will I
There
take
are,
bail?
there are, for that reason, warrant was issued. I have checked up the record.
Question is the order passed by the writ court is still in force.
Not
No, 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 no,
Sheet
no.
already submitted.
Submitted and warrant was issued against this Gopa.
Try.
Gopa
These all
Maiti confirmation.
I have checked up the record also. My lord.
Anyway, this
My
is,
lord,
you have
let
to
them-
very
We will
Arre,
Your lordship is entertaining this matter. It is a mini trial because petition.
No, let
who
me
said
go
I am
through-
saying it's a mini trial?
Let me go through the facts. Thereafter, I see the case diary.
Reducing
Yes,
evidence.
yes. My lord, case and
No, no.
Why should I go for evidence?
How far this many it is
Then you have to
maintainable?
go for section 482 IPC for inherent power of the court.
Question is, let me
My lord, no vacating application
let
has
me
been.
consider the facts of the case. I'll hear the state. I'll see the case diary. Thereafter, arrive
My
at
lord,
a
admitted the fact. Whatever stated by my lord.
Judgments where it is.
Very well. Your turn will come. You give your
My lord,
judgments.
my lord,
I have never interfered when they are speaking.
Yeah, please
Kindly go through the entire judgment of the Supreme Court. What the Supreme Court exactly says.
Judgment I've read.
Yes, please read it once again.
Don't misinterpret.
Arre, where have I misinterpreted? I haven't placed the judgment.
Yes, please.
My lord will kindly turn to page 14. My lord, the second last, 27th of November 2024, the petitioner Devabrata Bagh was arrested in spite of the pendency of this writ petition, and he was taken into custody. On 28th of November 2024, this honorable court was pleased to direct that in spite of the writ petition being pending before this honorable court, will not preclude the petitioner for moving his regular prayer for bail.
16 May 2020. In tribunal directing to the notated court system, the petition shall continue to further. 16 May 2025.
Now, what is the ground of challenge?
But I'll come to that.
First challenge for quashing the FIR. The other is with regard to that institution of that.
Mara, the first point that was raised by my learned friend with regard to this no coercive action Your Lordships will kindly take your Lordship's order of 16th of May 2025, whereby your Lordships have confirmed the no-go subscripts. Wait, I'll come to the Supreme Court later on. What was the date of the order passed by?
Order passed the 20 September.
September when?
Anyway, let him complete, please.
Which comes first, 16th May or September?
Let him complete.
You cannot go beyond the apex.
File a vacating application, I'll deal with it. You are not filing an application for vacating. Why? Then don't then let me allow my interim order.
Please let him complete.
Don't deviate.
Where have I deviated? I have not, even when you all were speaking, I have not opened my mouth because you all don't understand that when somebody else is speaking, you should not interject.
Anyway, please take your seat. Let him complete.
My Lord will kindly now turn to page 15.
Yes.
Your Lordships in the beginning had gone through the first information report where they had said that the property was valued at 60 lakhs odd. Your Lordships will kindly take the second paragraph of the 3rd of December 2024.
3/12/2024.
3/12/24, whereby the same de facto complainant had filed a civil suit
Yes. 3/12/2024.
So suddenly the 22 lakhs go vanishing from the original amount that was paid for in the FIR. Now, there is no gainsaying that this particular lady is a powerful political figure in the area. And just to keep me in custody, Mr. Devabroto Bak, this is what the police officer does, and the order passed by the learned magistrate. The Lordships will kindly turn to page 16. The second paragraph, the order dated 13th of December 2024, passed by the learned ACJM Ulberia. Lordships will kindly see the high-handed this.
Yes. Yes, that is thereafter 13/12.
13/12. Lordships will kindly go through this note that has been prepared. Supreme Court को order আছে। দুটোই দেখছি। একটা extra list of documents আছে? List of documents extra আছে? ধীরে না পরে দেখ।
So the fact of the case is still submission of the charge sheet, which you have challenged.
Subsequently, my lord, on 24th of December 2024, the petitioner was released on bail. Your lordships will get it at page 19.
Page 19 of?
Of the compilation. The last page.
No, this is page 90.
19.
19 is the statement of the Punjab Bank.
Madam, that is a compilation. Madam, this
Okay, this one.
path letter. Opposition to that. अरे हमारे लिए बिल्कुल नहीं।
Same opposition, non same all the complaint.
So you have come for quashing the entire case against you. That is WPA 27024.
I'm taking my vote. I actually
नोटा देना है तो
2024
ठीक है। Now the opposition that was filed by the de facto complaint, if your lordships can kindly take that up. My lord, to opposition soon will be
opposition on affidavit opposition. That's point number 5.
in 27605.
No, opposition, affidavit in opposition. Content manager backsheet. Intermount in the opposition. For 5, active opposition. এটা কোনটা নাম্বার পিটিশন নাম্বারটা
হ্যাঁ ঠিক আছে একই আছে মালাটকে নিয়ে নিন more or less the same opposition has been filed in all three. কোথায় আছে এটা নেই এটা গোপা মাইক
হ্যাঁ স্যার ওইটাই দিয়েছে ম্যাডাম এই সেম স্যার ওই সিওটা
আর তো অন্যটা বের করতে হবে এটা একটু ডিফারেন্ট আছে
অপোজিশন কথা অ্যাফিডেভিট
অপোজিশন
আমরা তো পাইনি
আমি আপনাকে অপোজিশন দেব ম্যাডাম অ্যাজ এ পিটিশনার
আমাদের অপোজিশন
আমি একটা অপোজিশন
ও কই আমার তো দাও
রেজিস্ট্রি ওদেরকে দিয়েছি সেমই আছে এটাই দিয়ে দাও 27024
এটা আমার
23635.
দুজনে রিসিভ আছে
না না
Or in the said opposition, your lordships will kindly come to page 3, my lord, the last paragraph.
7 এটা
Yes.
May I place it? In regard to paragraph 12 and 13, your answering respondents denied the same only to cover up the heinous offense of murder. My lord, there is no question now relating to murder. And there is no application filed for further investigation. And enacting the petitioner intentionally questions the character of the respondent number 6. Your respondent number 6 further states that rather the petitioner was previously married to a woman named Durga Pramanik, who happened to be a teacher in a government school at Shyampur. The petitioner severely beaten that lady as the lady showed the petitioner is doing illicit relationship with other lady. Srimati Durga Pramanik took divorce from the petitioner, and then the lady advocate who looked after the case of the petitioner thereafter, petitioner married her.
না কপি নেই একটাই আছে তবু
Lordships will kindly turn to page 5, paragraph 8. The way this particular paragraph has been affirmed, as true to my knowledge.
So that is also a question, how entire thing can be true to knowledge?
Because nowadays nobody checks. Whatever comes 1 to 6, 1 to 7, 1 to 8, true to my knowledge. Rest is record, rest is submission. Why not let them produce a single document to show that I was ever married to a lady called Durga Pramani, because I would be requesting your lordship's leave to file an application under 340 against this particular person for making such false, baseless, characteristic and scandalous remarks against my client. And that is their only defense. শুনছেন না কি বলেছে কোর্ট পিছনে দাঁড়িয়ে
Yes, you have also filed a reply to this?
This is our
This is their opposition,
yes,
respondent
reply.
number 6. Your reply?
বের কর তো।
Same opposition in all three matters.
No, almost same.
Almost.
Your lordships will get that at page 4, paragraph 10. And to my lord's affidavit reply given. 27024 there.
Bharat Singh Bulche in a writ petition. If there is no evidence in support of pleading, that is to be ignored. That is the law. I'm getting that judgment I have in our iPad.
Yes, affidavit in reply to the.
এ দেখো ট্যাক্সি হচ্ছে আদিত্য মন্ডলের অ্যাকাউন্ট হয়েছে 15 জুন ঠিক না এইটা
আচ্ছা
Yes.
My lord will kindly go through paragraph 4, sorry, page 4, paragraph 10. Of how we have dealt with paragraph 5.
Failure or evidence in support of suspect is not anything to the counter evidence. Whole defense is not
Citation number
1984 SCC. 1988 4. 1988. 53. Yeah. Unlike a suit in a writ court, suit is a real evidence. In a writ court, you have to plead and annex evidence in support of it. Otherwise, it will be ignored by court. Just pleading that has no basis. If that is not taken into account, there is no defense at all.
Yes.
My lord, we are specifically taking the plea that নতুন বিএনএস আমার হবে কোথায় গেল হ্যাঁ এটাই 246 বের কর সেবে না তো আর কি হবে রোজ ইউজ করে This is with regard to 340, 246 of the BNS dishonestly making a false claim. Has taken a specific pleading with regard to that. We are seeking leave from this honorable court to file an application.
No, question is your false declaration is with regard to this, that marriage and divorce, or entire thing is false?
The entire, my lord.
No, entire case is false means all these petitions have to be decided. But only your malignment against you regarding that marriage.
But even if one
divorce,
pack, even in a writ petition, or in a suit,
yes,
or whichever proceeding, if you cannot character assassination a person without any proof whatsoever in this regard.
What is with regard to offense? Here is with regard to a character of a person in a particular case. Of course, there is a good ground for defamation if it is proved to be false. But whether how far 240 is applicable here?
246, my lord.
246.
6.
That is
Yes.
akin to 340 of the
Okay,
old.
okay.
Dishonestly making a false claim.
Both the leave has been granted. I also paid for one leave to file a 340 application because they have also made my defamatory statement.
Now let us
against
see
my
the
client.
facts of the case thereafter. All this leave comes.
340.
So this is your affidavit in reply. Anyway, state has submitted any affidavit in opposition. State of West Bengal
Not despite order, only one affidavit has come, that is from the.
from the private respondent.
State has come. State was asked to produce the case diary, we have produced.
So you are not willing to. So you did not file your affidavit in opposition.
No, your lordship directs we can file.
No.
Direction is already there.
Direction.
But direction was to produce case diary, so we have Honorable Justice Tirthankar Ghosh directed us to only produce the case diary.
আপনি কি affidavit file করবেন?
So according to you, affidavit is not necessary. Affidavit in opposition.
But my lord, regarding fine, it's a writ petition, it's different, man.
You are representing whom? You are
representing writ petition number 7605.
But I am the de facto complainant, both the cases.
There, my
Yes, in both the cases.
All three cases, I am the de facto complainant, the respondent, who has the FIR maker.
totally different, my lord.
Anyway, yours is a different. I'm asking the state.
No, my lord, he,
State,
Didi, a second.
regarding
She is appearing for state in 27605 where we have paid for quashing.
We have paid for not for quashing. We have paid for
Whether the writ petition in which the FIR is challenged, okay, for quashing. Whether in this particular writ petition,
not
state,
in writ petition.
no, whether state has filed any affidavit in opposition or
Now,
not.
who is appearing in 27024?
Come to the prayer, my lord.
Didi, a second.
Already we have complied by filing charge sheet. So how this rate is maintainable?
No, maybe
That charge sheet has not been challenged also.
Car complaint.
That is why that is why you see when the FIR was challenged, the investigation was complete. So that is why the case diary is to be seen.
No.
If
There is a confusion. Let me tell you. Lord.
When FIR was challenged, investigation was in progress.
Yes, Lord.
Okay. Only there was a direction not to take coercive action, but
Lord,
there was no stay of the investigation.
Absolutely not. That is 27024. WP number 27024 file seeking quashing. Now, where my learned friend is appearing, that is not 27605 where I have paid for registration of FIR, and she is saying she has filed a charge sheet. Case me holo na charge sheet kise dite?
What is the prayer, my lord? Then come to writ petition number 27.
He has not challenged the charge sheet. Quashing
My
the charge sheet and further quashing.
Prayer, my lord.
Yes, 27.
Limited scope of prayer.
2765.
My lord. All are being tagged in such a haphazard way, my lord. My lord, this is gathered from which writ petition that is very.
Kindly come to page 17.
But the prayer are different.
On your you will get your turn. You will get your turn. Please hold your breath, bhai. You will get your turn. You will get your turn. Please hold your breath.
27605, my lord.
Page 17 of 27605. 27605 read to the.
All are analogously tied up, but all are different prayers.
Now, may I just show the sheet?
But they generate out of the same proceeding. What are you saying?
What you was, you produced the only case diary.
Yes.
And on it was on 14th of 11th of December 2024. And another case diary is on this.
শুধু রিডটা দাও না, শুধু রিডটা দাও।
This diary has to be produced.
That is the maintainability of writ petition, my lord. Writ petition is not maintainable at all.
Okay, 27.
27605, page 17. Page 17. Page 17.
My lord, come to the prayer portion. What my learned friend is agitating and submitting, that is quite different in my writ petition.
Acha, let us see.
Hope, my lord.
The question is, you are appearing for the state in one writ petition.
7605.
That you are appearing for the state.
Yes, my lord.
Okay.
Kindly see the prayers. A writ of nature of mandamus do issue calling upon the respondent authorities to look into the complaint made by the petitioner and to take appropriate steps in pursuance thereto within the time frame which is this honorable court may deem fit and proper. A writ of and or in the nature of mandamus do issue calling upon the respondent authorities to carry out investigation in respect of the allegations made by the petitioner in his complaint and to do appropriate justice thereto within the time frame. Writ in the nature of certiorari calling upon the for the records. So my prayer was for investigation in my complaint.
My lord, it is a time.
Please. So these grounds in the writ petition is this ground. So this is a ground to see as to whether the other investigation is genuine or not.
No, Lord. Let us finish, my lord, then I shall.
So you have come with a particular cause for registering of the FIR.
Because after death of Ardhendu on 4th September, 7th September, I lodged a complaint.
Yes.
I have filed this particular writ petition, which your lordship is now looking into, for registration of my complaint dated 7th September. Now, till date, there has not been any registration of FIR.
Now the question.
Are we in a relay race? Let me finish, then you argue. Are you in a relay race or chorus? Wait for your turn, please.
Yes, I'm waiting, but
But kindly. So 27605 has been filed seeking registration of an FIR on my complaint. Kindly see the complaint that is annexed with the writ petition.
No, I will not go into the merits. I'm just knowing the contents of your writ
Two
petition. No. He's submitting.
তোমার কিছু তারা আছে কোথাও যাবে তাহলে একটু ওয়েট করো আমায় বলতে দাও
No, you are for the state. The writ petitioner has not concluded.
Very exuberant state, my lord, I must say. Very exuberant and interested state in the matter. So 27605 is filed seeking registration of an FIR. As I have shown from the list of date, 4th Ardhendu died, 7th I lodged the complaint. So whether that discloses the cognizable offense or not, that your lordship will see in terms of Lolita Kumari. The state has not filed any affidavit in this matter. Since there is no case register, question of producing any case diary doesn't arise in this matter. But subject to correction by my lord, my case is very simple. I have lodged a complaint and I started by saying this, that this is the seat anchor, because ultimately the FIR that is paid for quashing in the other writ, initial allegation was that Ardhendu was murdered. Charge sheet has been filed that Ardhendu committed suicide. So since the state is now saying Ardhendu actually committed suicide according to them, so what about my complaint that Ardhendu committed suicide because of his wife? That angle should have been looked into. But kindly see what is the state coming up today. State is coming up with a story in the charge sheet that Ardhendu committed suicide. Because of me, I have abetted. That's the allegation today. Before everyone comes to court, I lodged a complaint saying that Ardhendu actually committed suicide because his wife was having an affair. So that angle should have been looked into, since you are concluding that he committed suicide. So in this affidavit petition, if no affidavit is filed, doctrine of non-traverse will apply. State has not said anything. There is no case diary that could be produced. Mr. Dey's Mr. Dey's matter I will address later on. Mr. Dey's matter, I have challenged the FIR. So there will be a case diary.
What Mr. Redulji was arguing.
Yes.
Okay.
Yes.
Up to now, Mr. Redulji was arguing on that particular.
Yes, my lord. Yes.
Okay, let him complete. Yes.
Yes.
Now I am just concerned with this quashing of this FIR. Okay. I am just concerned with this quashing of FIR.
2-7.
Whether it should be allowed or it should be doubted, because without perusing the case diary, without hearing the state advocate, I can.
My lord, we are not here to steal a march over them. We are not here to, my lord, get an ex parte order. My lord will hear everyone. What I'm trying to do, my lord, that there are 3 matters. It's my duty to clarify first with number wise.
One is with regard to registration of FIR, the other is with regard to
quashing
of FIR.
And the first one is with regard to the, my lord, attack on Gopa. Okay. That is 23635.
That is with regard to another complaint.
Another complaint of Gopa where she was attacked in the house. Now, my lord, what my learned friend is saying, that in this writ petition, it has been complied with. That 27605, she is saying she has complied with. Now,
she has to justify.
She has to justify that. Mr. Edulji is arguing on whether it is to be quashed or not, that FIR portion. That is 024.
27?
024.
My lord, regarding 27605, FIR has been registered being 36524 on 16/9/20.
You have filed your affidavit in that matter.
দিদি তুমি ভুল বলছো, ওটা অন্য এফআইআর।
605.
12/24 also, it's starting submitted within stipulated period of 89 days. We have submitted charge.
But that is in regard to the other case.
But what
No, other case.
what she is saying that on
And there it's noted the date. But see,
দিদি তুমি একটু ব্যাপারটা বোঝো, আমার
Now
কমপ্লেন্ট
you see.
হয়নি, আমার কমপ্লেন্টে কোনো এফআইআর হয়নি।
Prima facie case filled out, charge sheet submitted, my lord. My lord, if your lordship entertains.
No. You see, 23635
Yes.
by Gopa Maiti, that was the very first writ petition.
Street petition.
Okay. In that writ petition, are you for the state?
I am for the state.
Yes.
You are for the state. Did you file affidavit?
No, I intend to file one affidavit.
You did not file affidavit.
Till
With
date we have
regard
not
to the
filed.
registration of FIR.
No, that is not with regard to registration.
State perception.
That was action,
No, this is the very first.
Yes, I tell you.
Pray for safety and security of the petitioner in that.
একবার প্রেয়ার রিট পিটিশনটা দাও সিদ্ধার্থ দা।
Is inaction of the police authority.
Yes. Lord, what?
Okay,
635.
That is with regard to the police inaction, you have filed this writ
Yes.
petition.
Yes. Provide armed force guards.
Yes, that is.
Lord, I'm
that is
reading the
inaction.
prayer. Lord, I'm reading the prayer for my lord. My lord need not look into. Issue a writ in the nature of mandamus directing state respondents, their main and agents subordinate to forthwith take appropriate steps to ensure safety and security of the writ petitioner and provide armed police guard in such number as deemed fit and proper. Now, when this writ petition was taken up for the first time before Justice Rajashri Bharadwaj, state comes up and informs that there is an FIR lodged. Justice Bharadwaj says, don't take any coercive action. So this is the first writ petition where I have prayed that my house has been attacked.
Question is, prior to moving this writ petition, there was an information given to the police authority.
By my husband.
By me also, until to say.
By my
For
husband.
giving protection and information was given.
Yes. Yes.
Thereafter, you move the writ petition.
Yes. That is first writ petition.
Yes.
Seeking protection.
Okay, this is the first writ petition to which your learned friend has not filed any affidavit, but did you obtain any instructions, written instructions with regard to that, even if you have not filed?
তুমি কি affidavit file করবে? Lord, if they want to file, let them file. It's an assigned matter. We are not in a hurry.
Kindly consider the prayer itself, my lord.
না তুমি কি affidavit দেবে না আজকে argue করবে?
Question is, if you have not filed any affidavit, you see, this is a matter of 2024.
My lord.
Because till today, in spite of the leave being granted, you did not file affidavit.
My lord.
So did you take any instructions? Are you ready with any report? as
Well,
to
there are reports, I think, well, I believe there are 3 reports have been submitted.
on this writ petition?
My lord, my lord.
3 reports were
3
submitted.
reports have been submitted.
Okay.
Yes, yes.
So on which are the dates for submission of the reports?
One is, my lord, 30th June 2025. Second is, my lord, 29th of September 24. And another is, my lord, 23rd of September 24.
So according to you, 3 reports with regard to the writ petition has already been submitted.
My lord.
Okay, this is your instruction.
Well,
My
let
So
us
anyway, we
number
have
the
to
writ as
verify.
writ 1.
if-
Lord,
if
let
actual
us
report-
number this writ petition as writ 1. So that, Lord, there is no confusion. This is writ 1. So that, my lord, your lordship, Lord, it is
Writ
become
petition
easier.
number will suffice for us.
না না ওই যে
একটা
confusion
number তো
হচ্ছে
আছে,
না।
2365
মানে 1 নম্বর 2 নম্বর 3 নম্বর মামলা করে যদি যাওয়া হয় তাহলে একটু সুবিধা হবে।
করে লাভ কি আছে, এমনি করা যায় না?
Then the second one is 2.
In which I am appearing.
Yes, Mr. Dey is appearing.
No, one is by Gopa Maiti. Okay.
One is by Gopa Maiti seeking protection. That's the prayer.
That is seeking protection.
Seeking protection and armed
So
guard.
to this writ petition, according to your learned friend, 3 reports are submitted.
My lord.
That I do not have copies, my lord. তুমি কি affidavit দেবে জয়ন্ত?
হ্যাঁ বললাম।
তাহলে Lord, if my learned friend wants to use an affidavit, let him for once and for all use that and exhaust that. Because every time this is happening.
No.
My lord, only one thing, my lord. Regarding the, my lord, writ petition number 1, my lord.
Huh?
My lord, the warrant of arrest was issued by the.
Very well, even if a criminal, a warrant of arrest may be issued against a criminal, but no local persons cannot come and attack him. You see, that is why I am seeking report.
Yes.
You may say this person is
Ah.
criminal. That does not give you the power to bring local person and attack his house.
I have not been able to go.
Even if a habitual offender has to be proceeded in accordance with law.
Till that I am not being able to go back.
You cannot permit local persons to go and attack, even if an antisocial element.
Just তাহলে
So whether you see whether you are correct or whether your learned friend Mr. Chakraborty is correct, let the learned advocate for the state submit a report or affidavit in opposition. No, sir. Yes, every see, nobody. No. You see, nobody. No. That have to see the. Very well. I'm not. Whatever is issued, every citizen has a right under the constitution to get the protection. Yes, accordance with law. So it is for the state to say whether law has been violated or not. What steps you can let them say. You cannot have that knowledge.
No, I have seen that. That's why I am telling you, Lord.
Everybody can come and seek protection if his right is infringed.
By if warrant is issued, court that will take steps.
Warrant is issued, he may either surrender or he may proceed for stay of the order. There are legal.
I have a protection.
Whatever is there. But you see, if his house is attacked or if he's facing some threat, he has every right to come to the writ court to seek protection.
Till today,
whether his case is correct or it's a false case, it is for the state to submit a report. Very well. I shall see the report. Yes. Next petition.
this is one. Although they have not filed despite opportunities granted, if they want to file, let them file. Next, Devobroto Bag 27024. অর্ডারটা গুলো বার করো, কিছুই অর্ডার হাতের কাছে রেডি as usual.
Okay, Devobroto Bag
As usual.
CD has been produced. This is with regard to
quashing of the FIR.
that is the 3 item number 3.
No, that is 27024.
This is quashing of FIR.
Quashing of FIR.
That is under this for 306.
Yes. Now 306, initially 302.
Okay, with regard
Quashing of charge sheet and charge sheet. এখানে অর্ডার গুলো পারবো না যেখানে অ্যাফিডেভিট দিতে বলেছিল ওই অর্ডারস আর নট রেডি but I'm reading the prayers for my lord.
Just a minute. 2365 up to
2365 for protection.
Anyway, with regard to the other
27024.
Okay, this is for quashing.
So
you have brought the case diary. So after the writ petitioner concludes, I'll hear you and you may submit your case diary.
Yes.
So CD is there.
Yes.
Yes, regard to number 3. That
Not only one information to my lord. On 11th December 2024, in this writ petition, order was passed. I'm reading the order.
No, just a minute. Item number 3. That is also Devobroto Bag.
That is also Devobroto Bag. This is for registration of FIR.
This is the third one.
For registration of FIR.
Okay, first one was 23635.
Yes.
Second is for quashing 27024. Yes. And the third is 27603.
605 for registration of FIR.
Okay, this is subsequent to this quashing.
Yes.
Yes. Now, Mr. Edulji has submitted on this writ petition number 2 because you see, so for writ petitioner number 1 is concerned, WPA 1, that is for police protection, without Mr. Samanto filing affidavit in opposition and producing the report, it cannot be heard out.
Absolutely.
Okay.
I don't dispute that.
Okay, whether you are innocent or whether your client is guilty, everybody has to be proceeded in accordance with law and nobody can be attacked. Nobody's life cannot
But
be
even if I am guilty, my house cannot be attacked.
Yes. So what number 2 is concerned with regard to quashing.
Yes.
After you conclude.
Yes.
I have to hear.
So, I have only one humble request to your lordships and through your lordships to my learned senior friends that Lord, let the state learned advocate argue on the case basis. Mr. Dey is there, let only Mr. Dey argue and others not. আরে বাবা আরা যে লোকে এসে বলছে তুমি বলার আগে
I'll hear, no,
Yes.
I'll hear you on this petition regarding that quashing the FIR, I shall hear after the writ petitioner concludes.
Yes, আমরা তো সেটাই বলছি.
So have you concluded?
No, Lord, we'll take some.
No, 3 p.m. I have another fixed matter.
Lord, kindly fix on any other day. We will rely on some judgments and.
No, because you have to conclude this too. That is
Two.
for quashing.
Absolutely, that's the first writ petition that we want to move.
You have to move that because after you conclude, I have to hear.
Absolutely, Lord. So, Lord, in this writ petition, no affidavit is coming. Lord, my Lord may inquire from them. No one is going to file any affidavit.
No, the private respondent has filed.
Filed, but no further affidavit is needed. No further.
No, in this item 2, you are representing.
He is representing item 3.
3. I am not taking item 3 now. Definitely 3 you will get a chance. Item number 2, you are not appearing. That is Devobroto Bag 27024. That you are not appearing. Oh, you are appearing. Neither and Mr. Samant. Yes. So I am taking at present item number 2. Okay, on the next day. Yes, yes.
আরে বাবা নাম এক মানে কি মামলা এক?
Senior friend is addressing on behalf of the state. Let him address on the next.
Lord, only one clarification. Lord, may I ask this question to myself? Mr. Samanto in the first matter says he will file an affidavit. My learned friend, Mrs. Bordon is appearing in the third matter. Whether she will file any affidavit or not, Lord, that is not clear to me. Because no affidavit has come. In item number 2, case diary has come, I can understand. Lord, kindly, Lord.
Record an order.
Yes. করবে কি সেটা বলে দাও তুমি affidavit দেবে। তোমার মামলা তুমি affidavit দেবে।
Parties are present. Learned advocate appearing for state of West Bengal in WPA 23635 of 2024 submits that time be granted to file affidavit in opposition. That affidavit in opposition be filed within 3 weeks. Reply, if any, within 1 week thereafter. In writ WPA 270 of 2024.
27024, Lord.
27024 of 2024. Mr. Edulji will complete his submission on the next day. And thereafter, the learned advocate appearing for the state of West Bengal will submit. With regard to WPA 27605 of 2024, learned advocate appearing for the state of West Bengal may file affidavit in opposition within 2 weeks, 3 weeks, reply any within 1 week thereafter. So
2 or 3 টা একসাথে শুনতে হবে।
So shall I keep it after 4 weeks or after 2 weeks?
Lord, kindly keeps it after 4 weeks all the matters because only one reason.
Because I have to hear this matter first. 270.
Yes, but not only one request kindly consider from my side because second and third writ petitions are interlinked. It has to be heard one after another because my first point argument was that they now say it's a case of suicide. If it was a case of suicide, my complaint should have been looked into. Whether I am the abettor or his wife is the abettor.
Let all these matters appear.
Have to come after 4 weeks.
These matters appear. On 11 2025 26 at
11 February
2 p.m.
11 February হলে আমার ভালো লেগে
Lord, Lord, only one request. Lord, on the last occasion, my Lord allowed us to seek for an adjournment.
Yes, as the matter
Now,
is
Lord,
sub judice
Lord,
before
kindly stay it because the adjournment is refused. And see, this is the order. This is the order. They will arrest me. This is the order. Kindly see. Lord, let it be stayed. Let it be stayed.
As the matter is sub judice before this court, the parties may seek adjournment before the learned trial court, which may be considered.
Lord, the stay is not granted.
No, if on that,
This is my
I shall
application.
consider. Okay.
Kindly see what is the order. This is my application. What is the order passed? They are saying go and surrender.
I'm already on bail.
I'm already on no coercive action from your lordship's coordinate bench, and I'll go and surrender.
No. Question is, when is the date is fixed for consideration of charge?
No, not for charge. Date is fixed for my lord bail application. There is no bail application. Court says hearing of bail application.
No, question is, whenever a case is committed to sessions, that for confirmation of that bail, confirmation of that
Lord,
bail, that is-
Gopa has never asked for bail. Gopa has never asked for bail. Lord, I will beseech your lordship since your
question is, he is already on bail.
Lord, she has been protected by your lordship's coordinator bench. Justice Bharadwaj till disposal.
It is submitted.
Charge sheet submitted. No coercive action has been given.
Confirmed date on 16th May. My lord had confirmed it.
Your lordship has confirmed it on 16th of May.
My lord had confirmed it on 16th of May.
Lord, kindly read your lordship's order dated 16th May.
Now, so far, Mr. Debobroto Bag's petition is concerned, that bail has to be confirmed. Whatever is obtained from the
Lord, I will say since till 11th February, let everything be stayed. All the proceedings.
date, when is the date?
19th February.
लिखे नहीं था like as it is submitted by the learned advocate appearing for respondent number 6, that the next date fixed for the trial before the court of session is 16 to 2026. There is no necessity to pass any further order of stay at this stage.
My lord, your lordship's order. Lord, kindly have a look at your lordship's order dated. Very well. They will. Lord, they will shout. I cannot shout. Kindly have a look at.
Passing an order of stay because the date is fixed on 16 and 11 I am fixing it on 11. If on that day, if it cannot be concluded, I have to consider that.
My lord will kindly see your lordship's order of
16th May. একবার 16th May order টা দাও।
the no coercive steps passed by the court and bench. And now they are saying that
They may say, you see, they may say many things, but it is for the court to consider what is to be done.
My lord confirmed it.
Your lordship recorded the interim order directing police not to take any coercive action shall continue till this moment.
That is there, it will continue.
I'm saying you file a vacating application. Right, please file so I now deal with it.
Lord, I am amazed with this submission that one court, one of the honorable judge passes an order. I don't pray for vacating. I don't appeal against that. I come up and say that the Supreme Court has passed an order. According to that, your lordship's order gets automatically vacated. I don't know how these submissions could be made in before High Court. I'm very sorry to hear.
Okay, thank you. Yes, call the original side matter.
My lord, item number 39, both sides are here, my lord.
I'll take up original side matters now. Or tomorrow.
My lord, may I be permitted to mention, my lord, original side mentioning, my lord?
Yes.
Well, there is a 3 p.m. fixed matter, my lord. Appellate side.
My lord, for drawing up and completion of the decree passed by your lordship on 7th November, my lord.
Yes, give it.
But item number 2, my lord, it was fixed. But item number 2 was fixed today, my lord.
Original side is only the item, first item.
Yes, first item and second item.
The second item, I am seeking an accommodation, my lord.
Before my lord takes original side matter, before
Yes, any other mentioning?
before may I be permitted to mention, my lord?
Yes.
Before item number 7 of today's list, my lord. My lord,
I'm taking original side matters now.
I am just praying one thing, my lord. Today is fixed at 3 p.m. I have some personal difficulties if my lord fixes it next week. That's it.
Please come tomorrow, okay? Yes.
Number 1.
Matter, my lord. We have prepared the short notes of argument in terms of your lordship's last order.
You are for the defendant number?
1B to 1F.
1B to 1F. I have also, my lord, prepared my notes of argument.
Yes, record an order.
My lord, kindly take that my notes of argument on behalf of defendant number.
Yes, you give your names, all of you.
It is mentioned there. All mentioned, my lord.
Yes, record an order. Learned advocates for the parties are present. Today is fixed for submission of the written notes of argument by the parties. Learned advocates for the parties have submitted the written notes of argument. Let the same be kept with the record. The hearing of GA 23 of 2025 is concluded. CAB.
But one thing, the remuneration of the administrative administration remain due 1,53,500 up to December 2024.
Because you see, I have only determined now jurisdiction with this GA matter. You can take up this question after this. Acha, the learned advocates are requested to look into this matter with regard to the payment of remuneration to the learned administrator.
I have already
In the meantime,
written letter to the special officer.
yes, I have requested that they will look into this matter.
For item 2, my lord, I was led by Mr. Mitra, it's that probate matter, my lord, revocation of grant of probate. But he was to give a reply. My lord, the difficulty is that he had come to court, but he was feeling very unwell, so he left during the lunch break, my lord.
So I'm keeping it on Friday.
Friday, 16th.
Yes.
Your Lordship had directed that we file the compilation of judgments with the notes. Your Lordship takes it on.
From your side, it is over.
Yes, it's over, my lord. We were to just give a reply, my lord.
Mitra is to give the reply.
Reply, only reply.
Very
my lord.
basic points for your Lordship remember was on the limitation
fraud.
point and all. Limitation, I had stated that their handwriting experts report has not been proved on evidence.
You are opposing Mr. Mitro's application.
Yes.
And Mr. Mitro has concluded his, no, from your side, you are opposing, you have submitted. You have
They had cited 2 judgments, submitted fraud and forgery. I responded to that. I gave all 11 judgments.
for Mitro to give the reply.
Right,
To give
it was 11 judgments.
reply, the scope is limited
Yes,
on
only
the
to
points
the
of law and
clarification of the 611 judgments.
Distinguishing
Yes,
the
yes,
judge-
that-
distinguishing my
Yeah.
Nothing for me to do
No.
as such, your Lordship.
Yes, record an order.
My lordship is keeping on Friday at 3 p.m.
After the appellate side matters, it will remain in the list.
The issue is, your Lordship, if there's a 3:30.
That's the Friday. Generally, it's a 3:30.
Usually I take appellate side up to 12 p.m.
Oh, okay.
Usually.
Yes, yes.
Your Lordship just takes
Yes, learned advocates for the parties are present. Let the written notes of arguments filed by
with compilation of judgment.
Yes, filed by the opposite party
by the respondents.
Yes, by the respondent, PTA respondent, executor.
Executors heirs, your Lordship.
Heirs of
respondent, executors heirs be kept with the record. Let 16/1/2026 be fixed for giving reply by the learned advocate for the applicant in GA 2 of 2021. This is GA 2 of 2021.
Much.
Grateful.
ষোলো তারিখ লিস্টে থাকবে আর কি
Your Lordship has fixed a time, or has it, your Lordship,
it will remain in the list. Very few matters are kept in the list on Fridays.
Oh, grateful.
May I be humbly praying, my lord?
Yes.
In appellate side, item number 7 of today's is at fixed at 3 p.m. my lord. Due to paucity of time, the matter could not be taken up. If my lord keeps his next week, item number 7.
Let it be not this week.
Yes, my lord.
Let it be just not this week.
Item number 7.
Yes.
Deeply obliged.
এটা নিয়ে নেবে কথাটা